Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near. Give your attendance and you shall be heard.
Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have an opportunity to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light in the lectern will go off when you have 2 minutes left, or if you ask for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People versus Jordan Hewitt. Submitted. Wells Fargo versus Ferato.
Good afternoon, Your Honor. I'll request 10 minutes to reserve to that for the vote. Good afternoon, Your Honor. I'll request 6 minutes.
5 and 2 and 5. SC Children is submitted. Johnson versus Harlem Hospital.
For the respondent, 7 minutes, please.
6 and 2 and 6. Garta CL Atlantic versus New York City Office of Administration, Trials and Hearings.
Good afternoon, Your Honors. David Klaus of the law office, David S. Klausner, petitioner. 10 minutes. Respondent, 6 minutes.
I'll give you, do you want rebuttal time at all?
Yes, I'll take 8 and 2.
I'll give you 5 and, actually, I'll give you 4 and 1 and 4. Thank you. People versus Kenneth Johnson. Submitted. We have 2 appeals, Embark v. Bank of New York Mellon and Bank of New York Mellon versus Capital Research, which will be heard together, of course. Who's here for the appellant? Give you 6 and 2 and 6. People versus Jorge Guadalupe. Submitted. Trocom Construction v. City of New York. Who's for the appellant? How many minutes?
2.
Thank you. Okay. We'll go with 5 and 2, 3 for the city, and 2 and 2. Thank you. Okay, the next 2 cases will be heard together. Of course, Simon versus 4 World Trade Center, and Simon versus 4 World Trade Center.
World Trade Center requests 6 minutes and
Request 6 and 4, Your Honor.
I'll give you all 6 and 2 and 6 and 2 and 6 and 2. Thank you. People versus Harold Carter.
Appellant requests 5 and 2. Respondent requests 5.
4 and 1 and 4. Pisano versus Pisano.
Respondent, 3 minutes.
Okay, do you want 3 minutes?
2 minutes.
2 minutes is a deal. 2 minutes for respondent. UKI Freedom v. Organization for the Defense.
Appellant, Your Honors, 10 minutes and 5 on rebuttal. Respondent, UKI Freedom, 4 minutes.
Respondent, Azarac, 4 minutes.
I'll give you 5 and 2 and 4 and 4. Thank you. Cobblestone Lofts v. Admiral Indemnity.
Good afternoon, Your Honor. Gregory Lair for Great American, request 6 and 2. Good afternoon, Your Honor. Respondent request 5 minutes.
6 and 2 and 5. R.D. v. Miller. R.D. v. Miller? Submitted. People versus Amaury Perdomo.
I'll request 5 minutes and 1 rebuttal, please.
5 and 1 and 5. Dabrowski v. Abex Incorporated is submitted. First case up is Wells Fargo versus Ferato. Please.
Good afternoon, Your Honors, and may it please the Court. Anthony R. Filosa on behalf of Appellant Donna Ferato. The judgment of the Supreme Court should be reversed because the filing of the 2009 complaint and the 2009 foreclosure action accelerated the debt such that the commencement of this action in 2017 is barred by the 6-year statute of limitations. Plaintiff is stopped under FAPA's clarifications to CPLR 213-4 from contending.
Okay, so this was a $900,000 note initially, correct?
Correct.
And the last payment was made when, in 2009?
Correct.
Okay, is there a takings issue here?
There is no takings under this Court's analysis in Farkas, Dalal, with respect to the constitutionality,
Had
Your
those
Honor.
cases advanced as far as this one? I mean, here we have a judgment. There was a date given which was adjourned to do the foreclosure sale, but does that give rise to a property interest by the plaintiff?
No, it does not. No, first of all, with respect to just the plain language of FAPA in the sense that FAPA states that it applies until a judgment of foreclosure and sale has been enforced. And consistent with this Court's jurisprudence in Bank Arabique, in Nutt v. Cumming, which is a seminal Court of Appeals case, the term enforced in the common lexicon of foreclosure means the actual judicial sale of the property. So within the plain meaning of language of FAPA, there is no concern.
Right, so that would mean if they meant to say filed, like if the judgment had been filed, they would have said so.
Correct.
And they did not.
Correct. In the sense that, look, when a statute does not define a term, but that term has a definite meaning in legal parlance and even in common language, there's no need for a court to depart from either the defined legal term or the common parlance. And even as a matter of legislative intent, it would be incongruous, to say the least, to say that the legislature went to the trouble of enacting FAPA, which was to protect homeowners, only to have that salutary purpose undermined by a bank with the simple expedience of filing a notice of sale, even if that sale never went forward. So again, as a matter, we shouldn't impute an absurd result to the legislature in that respect.
Yeah, but the other side, as you know, accuses your client of engaging in chicanery. That's the word they use. And that, she delayed until finally FAPA was passed. And she, again, hasn't paid anything on this mortgage and has been living without having to pay anything on the debt since 2008, you said, or 2009? A long time.
So that, Your Honor, I'd say, look, one, we're a nation of laws. Ms. Ferato has every right to defend
But
herself.
the Constitution is a law, too. I mean, in other words, a takings provision is something to be...
Well, with respect to the takings provision, Your Honor, first and foremost, the plaintiff has to identify a cognizable property interest. They have not defined that property interest here. We do not have a final judgment. And even in the case of a final judgment, under matter of Hodes v. Axelrod, there is no per se prohibition against the application of retroactive legislation to a final judgment.
So were these issues dealt with at all before Supreme Court, the takings issue, the constitutional issue? Were they raised? Were they discussed?
It was not, because, again, FAPA was enacted after the
decision
for the Supreme Court, yes.
So since the plaintiff has raised those issues in his papers here to our court, and when there is a constitutional issue that's raised, we need to bring in the Attorney General. Is this something that we need to look at, have dealt with by Supreme Court before we make a ruling on the motion that's before us, the appeal that's before us?
No, Your Honor, because one, the plaintiff did notify the Attorney General. The Attorney General elected not to intervene. And this court has twice rejected takings clause challenges to the retroactive application of FAPA. In the Del Rio case, I'm quoting it, quote, FAPA did not affect a regulatory taking because FAPA did not permanently deprive plaintiff's mortgage of all value. To the extent that anything deprived plaintiff's mortgage of value, it was the 6-year statute of limitations itself. And that's exactly what transpired here, which began to accrue in 2009 when plaintiff accelerated the debt. That's this court's holding in Bank v. Del Rio.
You mean you have a judgment and then the legislature passes a new law which wipes out that judgment, and you say it's the 6-year statute of limitations that wiped it out? It's the new legislation that wiped it out.
Not in the sense, again, Your Honor, it's the operation of the statute of limitations. The statute of limitations was in effect, was 6 years at the time this action was commenced. It's 6 years in a post-FAPA world. So again, there is no protectable property interest here under the takings clause. And this court has, again, reaffirmed that in Dalal as well, because again, the plaintiff has no vested right, has no property right to reset or cancel the statute of limitations. And that's essentially the alleged taking that they are arguing here. That's just merely the operation of the statute of limitations. They have no one but themselves to blame that it took 5 foreclosure actions over a course of 16 years to actually bring this to a successful conclusion.
Thank you, counsel. You have time in rebuttal.
Good afternoon, Your Honors. Jordan Smith, may it please the court, on behalf of Ackerman LLP for the respondent.
Do you have a vested property right?
Well, a judgment is a form of property. The mortgage is property and it merged then into the judgment. And so that is a property right that was taken only by legislative action. And
Was there a judgment in Dalal?
I'm sorry?
Had a judgment been filed in Dalal?
I don't recall in the law if there was a judgment. I know most of the FAPA cases did not involve a judgment. But I would also say in this case, essentially all the FAPA issues are factual or require some factual development that obviously could not and did not occur in the trial court. To the extent FAPA is applicable at all, it has to be, there are 2 basic questions that have to be dealt with. One is whether the judgment was enforced by scheduling a sale, publishing, paying all the money that you have to do legal notices, arrange it with the court as has to be done in New York County.
Did you say to the extent that FAPA applies at all? Is
Yes.
that because you want us to revisit Genovese? You think we're going to do that?
No, I think it's because if you look at what FAPA's language it says, it doesn't apply if the judgment's been enforced. And you know, the scheduling of a sale has been held by a number of trial courts to be enforcement. It's not an issue that's been addressed at the appellate level yet. But I think there's a good argument that enforcement doesn't only mean the passage of title after a completed foreclosure sale.
I mean, haven't there been cases recently which specifically say that enforcement of a foreclosure judgment is understood as the conducting of the sale, not anything but that, which did not happen here?
I don't think that was, none of that's been in the context of this statute. And I think usually the language is used more loosely in those cases where the focus wasn't whether there was enforcement or not. And if the legislature wanted to say that enforcement was the passage of title after the sale or the conducting of the sale, they could have. But the enforcement is inherently a multi-step process. And even the Thomas case that they cite talks about, well, enforcement is the end or is not complete until there's been a sale. But that doesn't mean it hasn't happened at all. And so if you're going to set a bright line as to what enforcement is, it's really taking an action by the plaintiff in a foreclosure case to actually do that, because they're not completely in control of that. Technically, it's the referee who's doing it, and it's done with the court in many counties, including New York County, in terms of coordinating that, and that was all done here. So I think that's a factual question that obviously can't be in the record because it all happened after the judgment. And there's also the question of whether the instrument, they argue the 2009 foreclosure accelerated the debt. There's a question as to whether it's the same instrument at all, because
Right, because they argued in the 2009 foreclosure, which is the second foreclosure, right?
Right.
That you didn't, Wells Fargo didn't attach the correct
well, they argue it correctly.
loan documents, and you didn't. You in fact, there was a loan mod, and it wasn't attached to your complaint.
Correct, to that complaint. And the Court of Appeals made a distinction in Engel between which instrument was which, and the statute that this FAPA section that says that we're
It was meant to undo Engel.
yeah, but Engel had a number of different provisions, and the legislature can't undo a case by saying we don't like this case. They have to pass specific laws that deal with the provisions. And they didn't pass a law that changed that provision or that, I think, uncontroversial position that the loan mod is a different instrument than the underlying note and mortgage. And so in terms of the law, that's a 213.4a that says we're stopped from contesting whether there was an acceleration. It used the word of the instrument. And the language that is, the cases that have dealt with that, including this court, have talked about it being the same note and mortgage. And you're stopped from denying it. But it wasn't the same note and mortgage here, and this is a position that Ms. Ferato took throughout. Now, I would say none of this was developed
In the
below.
saga of this case, didn't we find before we were overruled and then the Court of Appeals was overruled, didn't we find in 2000, in the appeal from the 2000, in one of our appeals, didn't we find that the 2009 proceeding did accelerate the loan? Didn't we make a finding on that? And so is that somehow restored now because the Court of Appeals reversal of us was reversed by FAPA?
I don't think that's restored. I think it's, I would say the Engel decision would continue to hold on that particular narrow issue, even if not on, certain other aspects of how the statute of limitations accrues and maybe revoked.
If we are not to agree with the point that you're making here, your next best way of proceeding is to try to establish that it's a taking, isn't it?
Yes, absolutely. And as we said, we think the judgment is a vested right that has been completely eliminated by legislative action, which is a regulatory taking in the classic sense.
Thank you,
When you
Counsel.
notified the AG's office, was it with regard to the appeal?
There was service of our papers onto the Attorney General in this case, and they did not intervene.
Thank you, Counsel.
Thank
Any other questions? Thank you.
Thank you, Your Honors. Again, with respect to the takings clause issue, I would just direct the court's attention to 3 cases we cite in our brief where two cases from the Second Circuit, Hertel v. Callaway, 761 F3D 252, it's a 2014 Second Circuit case, holding that retroactive application of New York's increase to the homestead exemption to pre-existing judgments did not violate the takings clause. They pointed to the U.S. Supreme Court's case in Lucas, which essentially instructs that even if a regulation or a statute renders land, and here there's a question whether this test even applies to personal property like a mortgage, but we'll go down that route. Even if a regulation renders a property interest completely worthless, property interests are acquired subject to, quote, background principles of law. So the longstanding 6-year statute of limitations, which was always the statute of limitations before this action was commenced, the legislature's historical occupation of the field of the statute of limitations and the lawful means to extend the statute of limitations, let's not neglect that New York General Obligations Law 17-105 is a statute that was enacted in the 1960s, which prescribes the lawful means for a lender and a borrower to agree to extend the statute of limitations without resorting to such litigation abuses as the unilateral manipulation of the statute. That's another background principle of law that was in effect long before the ink was dry on the mortgage contract here. So there is no takings because they acquired their property interest, assuming we're categorizing either their mortgage or the judgment as a property interest. Those background principles of law in here in the title, there are a restraint on the title pursuant to Hertel, pursuant to Lucas. So pedigreed a principle of the state law adheres in the title itself so that the property owner can claim no taking when he essentially feels the effects of that restriction because the implication, the implied limitation has been there all along. With respect to, again, the application of FAPA to post-judgment, again, this is still the subject of a pending appeal. So there's no takings analysis when the action is still pending because there's still a timely appeal pending. So the legislature is free to change the rule of decision while the action is still pending. Going one step further.
Thank you very much. Thank you both.
Thank you.
Garta, CL Atlantic versus New York City Office of Administration.
You skip Johnson.
Johnson? I'm sorry, I missed Johnson. Pardon me. Sorry about that. Johnson v. Administrator, or as Administrator, thank you. Can't read my own handwriting. Please.
Good afternoon, Your Honors. May it please the Court, John Shep-Wong on behalf of the appellants. This Court doesn't have to get into the substance of the plaintiff's experts' opinions here because they are insufficient on their face for a couple of reasons. First, their experts were anonymous, so their opinions couldn't be considered.
Well, they're always, the plaintiff's experts are always anonymous in mid-mal cases.
That's right, Your Honor.
Doing that for years.
They're often anonymous, that's right, Your Honor, but I think the case law bears out that if the defense is denied the opportunity to establish, to confirm that these experts are who they say they are, and makes a request below that the unredacted or de-anonymized affidavit to be submitted to the court, then...
The judge was able to evaluate that. I don't think that's your strongest argument, frankly. Why don't you move on?
All right, Your Honor. Well, fair enough, Your Honor. Thank you. The second point we would make on the sufficiency of the affidavits is that they were just not qualified. They didn't state any relevant qualifications to establish that.
Well, let's just take the first one on the issue of the bowel obstruction. Plaintiff proffered a gastroenterologist. It doesn't have to be a surgeon because surgical techniques is not an issue here. What's at issue is whether the 2-day delay was a departure or not. And a gastroenterologist, as I understand it, is fair to give an opinion in that context. Why do you think otherwise?
Respectfully, Your Honor, I think we disagree in terms of what the expertise that needed to happen here, what the decision was that is the basis for arguing that there was a departure from the standard of care. It's whether the risks of surgery outweighed, or the risks to her from not performing the surgery outweighed the risks to her from her pre-existing conditions. So it's a surgical decision as to whether to proceed, as to whether she would have been able to heal. There were multiple indications from our expert that said that her pre-existing comorbidities caused a heightened risk that made delaying surgery appropriate. Now, whether that was correct or not is a surgical decision. It requires surgical expertise in terms of what they could do with the surgery, and as well as what the aftermath would be in light of the individual's.
Again, maybe I'm missing something, counsel. The surgery was done 2 days later, confirmed perforation. There were subsequent surgeries. I don't think that's the issue. The issue they're claiming is when she was diagnosed on presentation with air in the peritoneum, did that warrant an emergent reaction? That's their position, and your position is she was doing well with the numbers, and that we didn't have to rush. But she survived 4 surgeries, so obviously, even though the risks were there, she needed the surgery. The question is whether it should have been done 2 days earlier. Did I miss their issue?
Well, I think that the reasonableness of the decision to
Wait 2 days.
Try to treat it non-surgically for 2 days, the reasonableness of that decision turns on whether the risks of surgery were, as Dr. Wishner said that they were, that these...
Even if their expert was not an expert in surgery, but was a gastroenterological expert, and he was able to evaluate that. I mean, this is something that you put before a jury, and you can, I mean, it's not that they don't have any expertise. You may say your person has better expertise, but I don't see that you can say they can't comment on a gastroenterological issue just because they're not the surgeon, and whether surgery makes sense or with all the comorbidities you would not have done it. It didn't, the claim wasn't that the surgery was done wrong, it was that they waited, and I think that this expert could at least opine as to that.
Well, I think, Your Honor, that we need to remember that gastroenterology and gastrointestinal surgery are 2 separate disciplines. I think that if the gastroenterologist here wanted to explain how he had knowledge about when surgery should be conducted and when they shouldn't based on his gastroenterology experience, then he should have explained that in his opinion, but he didn't. What he said was, I'm a gastroenterologist, and therefore I know all about surgery, when those are 2 separate disciplines, Your Honor. So I think that the burden here was on plaintiffs to explain how to make that inferential leap between gastroenterology and surgery. And just on the qualifications point as well, with regard to the skin care geriatrician individual. So this person just said that they were a geriatrician. They claimed no specific experience with regard to wound care or with regard to pressure injuries. They just said that they have older patients. That too is not a statement of relevant experience.
Also, before you sit down, speaking about the skincare issue, how do we evaluate Nurse Rome's testimony, given that she didn't talk about whether or not the protocol was actually adhered to? In other words, that it was properly documented that whatever was necessary to alleviate the ulcers occurred. So she says that it wasn't a departure, but it sounds like she's saying the protocol is not a departure, not whether the actual implementation of the protocol was a departure. How do you deal with that?
Well, I think that, Your Honor, that there is a misreading on the record on the part of plaintiffs here that there wasn't records demonstrating that they complied with every step of the care plan. I think that they are asking for a record-keeping standard that this court has rejected in Brownstein. So I think that that's the first point. And I think that with regard to the care plan, I think that it's a misstatement to say that 2-hour positioning, which is what Your Honor is referring to, was required, that it was 2-hour positioning to the extent that it was possible, feasible, to the extent that it was consistent with other requirements of her care, and the record showed that all of this occurred. We cite in our reply brief extensively, Your Honor, points where the records show that 2QH or 2QHR, which means twice, which means every 2 hours, that this occurred during the course of her 3 months of treatment. And the fact that, there are consistent indications within the records that state that they've continued to apply the same care plan, applied the same care plan, multiple indications of individual turning being shown in the records. And so there's requirement that it has to be perfect in order to establish a right to summary judgment just doesn't exist, Your Honor.
Okay, thank you. You have time in rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the court. My name is Kristen Janaris for the plaintiff respondent.
So would you pick up that thread? Let's talk about skincare first, since
course.
you just talked about it.
It's actually where I was going to start, Your Honor. Nurse Rome's affidavit on this issue was irredeemably flawed. She failed to reconcile her opinions with the actual medical record, which plainly do not show that this patient was being consistently turned and repositioned, much less every 2 hours as per her care plan. And
What about your
defendant's
colleague's
argument...
point? I'm sorry to interrupt you, counsel. What about your colleague's point that we don't need chapter and verse or crossing all the T's and all the I's to document the protocol, just that it was done? What do you say about that?
Well, Your Honor, there's an astounding at least 28 days for which there is no documentation whatsoever of this patient being turned and repositioned. And for context, she was hospitalized for 88 days, so just about a third of her entire hospitalization. We have no records of this patient being turned or repositioned. And what we have is evidence of her pressure ulcers progressively getting worse in size, worse in stage, becoming necrotic, requiring debridements. And on that point, I would refer this court to its holdings in Bradley, Pichardo, and Reap, which all recognize that in a pressure sore case, summary judgment is not appropriate where there is a large lapse of documentation as to the patient being turned.
Even acknowledging that there was a lack of documentation in the record, what about the proximate cause issue? Given that the decedent came in with so many comorbidities, and based upon everything that happened during that 88 days of hospitalization, how were you able to show proximate cause?
Sure, and I'd like to respond to that point with two points. First and foremost, Nurse Rome's affidavit never addresses this issue. The burden of proof never shifts to plaintiff, where this was specifically alleged in the BP at page 232, and Nurse Rome's affidavit is completely silent on this issue. But even
I'm sorry, I don't mean to cut you off, but I got the impression she did opine about the comorbidities impact on the protocols. For example, the positioning of the decedent in the bed in terms of the breathing and all that entailed, because that was the correct thing to do to help her with that issue, obviously put more pressure to exacerbate the sacral ulcer.
On the sacral,
so that was an actual opinion saying, look, here we have a comorbidity that's impacting, regardless of what we do, to try and heal the ulcer, correct?
Your Honor, even that opinion was flawed, though. As we point out in our brief, It's documented in the record that there were measures available to offset the pressure on her sacrum, which is where the pressure was applied because her head had to be at 30 degrees. So they offered pillows to, quote, offload the sacrum, and on other occasions, they wrote that she was placed off of the sacrum, and I can provide record sites for that, actually. I'm sorry. Well, I'll give you those record sites in a moment.
But more importantly, to pick up on what my colleague asked you, what, in your expert's opinion on the skin condition issue, what was said that, with an opinion of a reasonable degree of medical certainty, that the ulcers, the heel ulcers and the sacral ulcers, as advanced as they were, caused the wrongful death of this patient?
Your Honor, the expert opined that these contributed to her ultimate decline, and the autopsy report supports that opinion. The autopsy report notes that she was found deceased with multiple debicuitous ulcers throughout her body, and furthermore, the autopsy report specifically noted that her high-grade debicuitous ulcers led to her grim prognosis. That's
So before your time is up, I want to turn your attention to the bowel issue. Where is the malpractice? I mean, she comes in on June 26th and with a lot of comorbidities, and Dr. Schumann tries a conservative approach to treatment, and her numbers start getting better. Did he not conduct himself properly and not immediately going to surgery, especially when he sees that the numbers start getting better?
So her numbers initially improved, but several hours, around 9 o'clock that night on June 26, her numbers actually all elevate. Her lactate and her white blood cell count goes up again. Later on, a few hours later, there's an abdominal examination. That examination elicited tenderness and guarding, which is significant because Dr. Suman testified as his deposition that those signs warrant surgical intervention because it means the patient is experiencing generalized peritonitis. And yet, he still declined to operate that day, even though by his own definition, she presented with surgical signs for surgery. And that was never done. And that was part of the prima facie deficiency in their own papers, where they failed to completely address this contradictory evidence.
So what reason is there to think that had he operated more quickly that there would have been a difference in the outcome?
Sure. So Dr. Suman testified that when he finally performed the delayed surgery on June 28th, he opened her abdomen and he saw fecal content, peritonitis all throughout the abdomen, as well as severe intra-abdominal sepsis. A few days later on July 4th, when he performs his second surgery, he reopens the bowel and notices that the previously healthy parts of her colon were all necrosed, meaning dying tissue. And Dr. Suman testified that that can occur when a patient has sepsis, which is exactly what the patient here had. So that creates this causal link of developing sepsis from this delay. There was a perforation that was leaking bowel content that caused confirmed peritonitis. And thereafter, she has necrosed bowel that occurred as a result of that sepsis, as per Dr. Suman's own testimony. So that is the causal link to showing why this delay in surgery caused all these further problems for this patient.
Thank you, counsel.
Thank you, Your Honors.
Any other questions?
So first, with regard to the proximate causation, that Ms. Rome's opinion. So the prima facie case was never challenged below at number one. I think that that's important because they failed to preserve any challenge on the prima facie aspect of this.
Are you focusing on the skin condition, the bowel obstruction, or what?
That applies to both of their objections to our expert affidavits. So I just would point out that the court should just move past the prima facie issue here completely because they didn't preserve it and denied an opportunity to us to respond. But the point is, with regard to Ms. Rome's affidavit, which is the skincare nurse, our expert on that, she specifically states at 6603 in the record, in her opinion, paragraphs 29 and 30, exactly what caused the pressure ulcers here and why the doctors couldn't do anything about them, why they took heroic steps, frankly, to treat these injuries, but that given the comorbidities and the nature of what else had to be done, including the bed elevation and the other care that she required.
So I'm sorry, what was the record site for that?
6603, Your Honor, that's Ms. Rome's affidavit. So if you look at paragraph 29 and paragraph 30, she goes into great detail as to why the comorbidities and all of the other instances, including 60 centimeters of her bowel being removed, contributed and were the actual cause for the pressure ulcers here. And I think to the point with regard...
Just address the fact that there's such a lapse in the medical record for treatment for 28 days with regard to moving her so that she wouldn't be exacerbating these ulcers?
I think, Your Honor, that counsel overstates a bit what the records actually show here. I think that we cite in our brief several pages where we, dispute the number of days that there was no record keeping in terms of the repositioning and things like that. That includes the actual many indications in the record where two-hour turning was performed, as well as individual indications on specific days that counsel says that there was nothing there. There were either indications that turning was performed or indications that care was actually provided consistent with the care plan. And I think that's enough for a prima facie case, as well as to support Ms. Rome's opinion, which, again, was not rebutted with anything other than a conclusory opinion from their expert that every kind of pressure ulcer was negligent. Thank you, Your Honor.
Matter of Garta. Please.
Thank you, Your Honors. My name is David Klausner, Law Office David S. Klausner, on behalf of the petitioner appellant on this Article 78 transfer, which to this day is still confusing to me in terms of the procedure. The question before this court is I believe, a matter of first impression, and which is whether an armored truck, which is responsible for ultimately delivering or transferring cash and coins from what is the equivalent of a mobile bank vault.
Yeah, we know the facts, counsel. And you make it's a substantial evidence question, so it's difficult for you, of course. It's a hard standard to meet. But here you have changes in policy, apparently, by the agency. So, first of all, is there anything about the variance that's in the record before us? The variance that you mentioned, there's nothing, right?
No, the variance has been granted. It was.
I know, but do we have record evidence of that? I mean, like, how does that get before us? We just take judicial notice of that? Is it
I think you
published
should
somewhere?
take judicial notice of it because it didn't exist when any of the papers were ultimately submitted.
Where is it published?
Where is it published? It's on the website for the DEP. The variance was an application process which began, and it took about 9 months for them to have a hearing, and ultimately then it was granted and made effective conditionally on October 11, 2024.
Well, that's part of this pattern that you do a good job in your brief talking about, which is the change in policy, the alleged change in policy. Tell us why that means that this is somehow arbitrary and capricious or does not satisfy the substantial evidence question.
Your Honor, I do not believe that the change in policy, I think the change in policy was reflective because one of the arguments that it was consistently made by DEP in the hearing stages of these cases, and I need to point out that before the oath appellate decision, which overturned this, there were 19 separate oath hearing officers that issued 263 dismissals on this exact same
including the hearing officer in this case.
Including this one, H.O. Rubin, which his decision was good, but there are other ones which were far more developed than this.
Point of information, did all those decisions focus on the accuracy of the idling time? Could that seem to be the bulk? Okay. Did they all say uniformly that delivery of cash is a process as defined in the applicable regulation?
Yes, they all concluded that they were entitled to the processing device exception under 39301, and that processing device exception, which is in the definition, I mean, I could read it ultimately to you, but the key parts of that definition, and I'll read it verbatim because I think it's important.
Counsel, we know the definition. Doesn't it run athwart the other rule that says that air conditioning does not count?
No, see, air conditioning for comfort doesn't count. See, the idea here is that you're not supposed to idle for more than 3 minutes, but we have exceptions that were ultimately carved out by these rules and regulations. Emergency vehicles, not at burden. processing devices, which was not defined in the idling thing, but then came in this later thing because there was ambiguity. And the processing device exception basically requires a mechanical connection to the engine to accomplish the key function of which it's entitled to. The Garta vehicles and armored cars, this is a very unique thing. There's not precedent that's going to apply to other things. This is not Amazon, not FedEx,
Even
not
in
UPS.
this situation itself, don't we find that the facts are that originally the city took the position, they said it's okay, you can idle.
Yes.
And then they had this interim period, and they decided it's no good, and then they come back and say, and now they're saying you can use the air conditioning and idle in this way, right?
Right.
Is there any explanation offered why they're forth and back and forth?
If you want me to speculate, I can. The Citizen Complainant Program, which ultimately is derived from this, essentially authorizes a group of individuals, bounty hunters, who collect money and follow these trucks around and videotape them, submit them through a portal. And at the time that the H.O. Rubin decision was issued, Your Honors, the stated policy of the DEP was, we don't ticket armored trucks engaged in their process.
There was never a variance before,
No.
a formal variance.
No.
There was just a policy understanding.
Correct. And in
that-
2018, I think, or 2019, we reached out to Alyssa Preston, who is the one of the attorneys there.
Yes.
We asked this very question because we started getting these all of a sudden. And she said, our inspectors are instructed not to ticket these vehicles when they're doing what they're supposed to be doing, which is at service stops. And you don't need to do a variance. We relied upon that. We were then successful.
And you
by
put
getting a
that in
dismissal.
the record, right?
Yes,
We
that's in
saw
the
that
record.
in the record.
We were then successful in getting the dismissal on the basis of this processing device exception. In addition to which, the citizen complainants have to go to a website, and they have to go through this process. I know I'm being redundant with the word process, and they're supposed to check off, is this vehicle engaged in process, and that they actually included armored trucks in this list. If they selected yes, it says go no further, you're done. So they clearly did not do that, and they went forward with it. Once this decision came out, 2 days later, they scrubbed the website, and they changed it and removed armored trucks from it. In addition to which, we got an email from Ms. Preston saying, it's no longer our policy to do it, you need to get a variance, which we then promptly, ultimately did to do so. The issues that we have is, see, what the appellate division
Any
did.
other questions?
This time,
Counsel, you have time in rebuttal, don't worry.
can I just make one point, Your Honor, which is the
30
issue of
seconds.
goods and the difference between what
That's
are
not a
goods
good,
and
I don't
everything
think
else?
that's a very
You
good.
don't want to get, that makes your head spin? Me too.
No, it doesn't seem, money is not the same as like clams, like I can understand why clams need to be refrigerated, but not money. So, and why money also can be goods. It can also be personality.
Well,
Anyway,
again, the issue of refrigeration, though,
if
is
you
not.
want to nail that topic on rebuttal, you go ahead.
Okay, thank you, Your Honor.
You're welcome.
Ian Sinclair for respondents.
So I'm interested, what is the effect of the variance? Because obviously they're able to do what they're doing now going forward after October of 2024. Does it vitiate all those summonses in your money grab here?
I believe I'm not, I didn't work on the variance, and it's not in the record, but my understanding is that the variance applies after the effective date of the variance until.
So then they would
extent
be
of
on the
variance.
hook for about 45 summonses or whatever is outstanding.
Well, I think there are thousands of summons that predate the variance.
How many summonses are outstanding?
I'm sorry?
How
I
many
know
summonses?
2022 there were 45. I'm just,
Or outstanding.
Outstanding.
I mean, isn't it at the height of arbitrary action? If this is such a horrible process, you used to allow it, you stop allowing it, now you're going to allow it again. What's the justification for this difference in treatment?
Sure. So a couple points. First is that DEP. So just talked about the enforcement protocol. So the board carefully. Ultimately, this question is about the Environmental Control Board's determination, and the Environmental Control Board carefully considered the 2018 email and the undated screenshot. And just to talk about what the email actually says. The email which the board found, all it shows is that DEP did not enforce the anti-idling provisions against vehicles that were in process, which is basically the standard that existed before the definition was promulgated. There was a standard that OATH applied called looking at whether vehicles were in process. That was the standard prior to mid-2022. Then the definition of processing device was promulgated by DEP. It changed the rule. So the 2018 email says, if you look at it, it's on page.
So you're saying there was no change in policy?
I'm saying that.
I mean, what about all the hearing officer decisions that found, in favor of the?
Right. So to talk about the board here is the final administrative decision maker, and that's the decision that we're looking at in this determination, right? And nothing requires that they afford deference to the hearing officers.
Well, that seems a little disconcerting. I mean, what do you have the hearing officers for if you're not going to give any deference to their findings? They actually hear the witnesses. I mean, this wasn't the longest decision in the world, I granted, but he talked about what he found, and he found that it was in process, and so did many other hearing officers. And the board says, "Well, that's very nice, but we disagree." So, I mean, it seems a little arbitrary.
Well, I think on the particular deference, in the decision the oath decision that petitioner cites on reply, DEP versus Ryder Truck Rental, it does state that witness credibility, in particular, that the board generally gives deference to the hearing officer's decision as to witness credibility. But this case did not really turn on witness credibility. It's about written submissions. It's about photographic and video evidence. And in the very next statement,
what's the justification for the change in approach? I mean, if it was wrong during this interim period, so it should have been wrong throughout. And if it's not, why should they be hit with these $350 fines for running the air conditioning?
I don't know exactly. I mean, DEP's, what changed between 2018 when the email, mid-2018 when that email was drafted, or the email that was sent, and 2022, a couple of things took place. I don't know exactly why DEP's policy changed, or their enforcement protocol changed, but I think there's a couple things to point out. One is that DEP is not the only enforcement agency for the air code. Citizen complainants can bring them directly.
So obviously you've come to the conclusion it's okay to be idling to have the air conditioning in this sort of a situation. So it's very easy to rectify the problem, and that's by not upsetting the decision of the hearing officer, which said they don't have to pay these summonses.
I don't recall any part where there was agreement that you can idle for air conditioning. That's explicitly cut out of the rule.
The variance allows it, right?
The variance is a conditional variance, so it requires Garta's trucks to comply.
That would cover this, what we have here, wouldn't it?
Well, because the variance is not in the record, it's difficult to discuss it, but it requires Garta to essentially electrify their trucks or install anti-idling technology so they don't violate the rule. So there's not a concession to Garta in this case. They're complying with the regulation. That's the condition of the variance. And it's not forever. They have to demonstrate compliance over time.
Is there any history in Administrative Code 24163A indicating that armored vehicles should fall within this processing exception?
No, nothing about the statute speaks to armored trucks in particular, and nothing in the legislative history of the regulation itself speaks to it either. This is the definition was promulgated to address what DEP ultimately found to be an insufficient standard that OATH had developed over time about what it meant to be in process. And that's what Hearing Officer Rubin's decision says. It says the truck is in process. That's the previous standard, not even the processing device.
You said that they would try to give deference to the witnesses, and he found after hearing the testimony, I do not find that petitioner's video conclusively establishes that the cited vehicle was idling for 3 continuous minutes. So he just found that the testimony there wasn't even enough to hold this person.
Well, I'll just say the next sentence in that same decision that petitioner cites.
Yeah, I saw that.
Sorry?
No, I see that.
Yeah, it says that the board generally affords deference unless it's made against the weight of the credible evidence, such as where there's more persuasive evidence in the record that was overlooked or improperly addressed, which is more of a de novo review. They're looking at the entirety, and here they saw the same video evidence. They saw all the 5 written submissions that Garta submitted. They looked at that evidence, and they found that the hearing officer did not decide correctly, and that it did not comply with the pretty clear definition of processing device. Because all of those systems, they only exist for the purpose of effectuating the safe transfer of currency.
Counsel, we have one more question for you.
Just one follow-up
Yep.
quickly. Your friend mentioned hundreds of dismissals like the one below here. Did the board weigh in? Were there appeals of those dismissals?
I don't think this particular decision discussed those other hearings.
No, but I'm saying you could take notice of your own records. He said there were hundreds of dismissals on the very same issue by hearing officers like the one here. Now I'm asking you, did the board weigh in and reverse those, or did they affirm those or do nothing?
I guess it would depend on if, for each one, it depends on if DEP appealed. I don't know the specific, I mean, DEP appealed several of these, and the board has since found that armored trucks are not a processing device in many subsequent decisions, though I imagine folks have stopped appealing because that precedent is applying. But just on that particular note, this also isn't the determinative decision for all armored trucks. If a future armored truck shows that there is some other distinct function, then they can qualify under the definition of processing device, but they didn't hear based on the evidence presented. And that's the core of this decision, and that's why this court should affirm. Thank you.
Your Honor, to answer your question, the precedent that exists that is ultimately the subject of this review was used to set aside many of, or the majority of the decisions that resulted in dismissals. A point that I need to make, and because it was talked about the variance, but put that aside, Garta is committed to an environmental responsibility, and as of now, their trucks are either all electric, which is a very complicated thing given charging infrastructure, or equipped with anti-idling technology, and is now 100% compliant with the anti-idling law. It just took time to ultimately get about to do that, notwithstanding the fact that people were following these vehicles around. The decision that would reverse this was, I believe, a decision which was designed to achieve a result, and it was done so in an arbitrary and capricious way and completely misinterpreted the law that exists. Our brief is very clear on that statement, and I believe that if you look at that and apply the correct standards to it, the Garta vehicle was engaged in process. When it stopped, it is a very unique vehicle, and somebody has to remain inside of it at all times in a sealed compartment. And we don't prioritize one group of people for clean air versus another person who's entitled to breathable air. This is not
You've got a
comfort.
good policy argument. We're not beefing
I understand
about
that, but I believe that there was a policy component to be on there. So thank you very much, Your Honors. If there's any other questions, I'll be happy to answer.
Any other questions? Thank you, counsel. Thank you both.
Thank you so much.
Embark versus Bank of New York Mellon. Please.
Good afternoon, Your Honors. May it please the court, Dan Fleeman, Paul Hastings for the appellants. Embark borrowed $1.5 billion from my clients and others. Embark is a holding company, has no operations, has no income. Its only assets is the equity that it owns in its subsidiaries. So the question in this litigation is if the indenture that governs the notes prohibited Embark from giving away $5.5 billion of equity value. The trial court held that the indenture did not prohibit this.
Right. It only applied to Embark and its restricted subsidiary, which there is one restricted subsidiary, correct?
That's correct, Your Honor.
Okay, so if it was going to talk about the other subsidiaries, shouldn't it have done so clearly? Because Judge Maisley found that's unambiguous.
Agreed with that, Your Honor. The equal and ratable provision talks about Embark and the restricted subsidiaries. The focus of our litigation, the default that we have asserted, is at the Embark entity, looking at the property of Embark itself.
You're saying that the equity of these other non-restricted subsidiaries, the equity is property of Embark, right?
Is the only property
That's the
of Embark.
core of your argument.
Correct, Your Honor. Correct, Your Honor. And if that equity value is gone, there is no value to repay these bonds, right? These bonds were issued in 2006 because of the fact that the subsidiaries had value that was feeding into Embark, which again is a holding company with no value.
So what prohibited them, what contractual provision prohibited them from transferring the equity of these non-restricted subsidiaries? Where does it say that they're not allowed to do that?
There's no prohibition on the ability to transfer the equity in the subsidiaries, Your Honor. What there is a prohibition on in the equal and ratable clause is to the extent that new debt is going to be incurred, that new debt cannot be placed in a way that creates liens on property of Embark, and that's exactly what happened here.
You agreed that guarantees are not liens.
That issue ended up not being in litigation here, Your Honor. We do believe, in fact, the guarantees are on liens, but that doesn't matter here, respectfully, Your Honor, because what ended up happening is, by virtue of the security interests and the guarantees that were issued by the subsidiaries, the equity value was subjected to a lien. Because when we look at the definition of lien in the indenture, it's much broader than encumbrance, right? The definition of lien in this indenture includes preference, priority, and a preferential arrangement of any kind or nature whatsoever. The equity value that Embark holds in subsidiaries, the only asset it has, was subjected to a preference, priority, and preferential arrangement in favor of the LBO lenders. They now sit $5.5 billion ahead of Embark's equity and ahead of my clients who sit just at Embark.
Was there any notice to your clients when they entered into this arrangement?
There was, in connection with the leveraged buyout, there was an announcement that the leveraged buyout would occur, and then there was a regulatory process of a delay before it happened. During that period of time, as set forth in the record, we had reached out to Embark. We let them know that we thought that there was a violation happening. The record will also show we actually sent them a notice of default in draft form, letting them know these are the ways that we believe you're about to violate the indenture. They proceeded with the transaction nonetheless. We believe the trial court's decision should be reversed for various reasons. The first one I will note is that the trial court rewrote the definition of property that was in the indenture. The court inserted a tangibility requirement which is not found in the definition of property. Property as defined in this indenture says any asset or property of a person, and then it says including any interest thereon or income or profits thereof. These are all things that are property, very, very broad definition. The trial court inserted a requirement that property must be tangible, which is not in the indenture, and as a matter of fact contradicts the definition. Because if you're going to include things like income and profits, which indisputably are not tangible, you can't then go ahead and say that property must be tangible. And this was critical to the trial court's determination that equity value is not property. It was the misapplication by rewriting the definition to say that property can only be things that are tangible, which is not supported by the document and not supported by the definition itself. The trial court's decision also leads to a commercially unreasonable result. Notwithstanding, the trial court's determination basically says that it doesn't matter what happens outside of Embark. Notwithstanding that Embark itself causes those things to happen, that Embark loses billions of dollars of value, and notwithstanding that it deprives my clients and note holders to their only source of recovery, that nonetheless, the Equal and Ratable Clause doesn't protect it. And the trial court's finding really renders the Equal and Ratable Clause completely meaningless, and this is why. Embark's only asset is the equity. And if you're going to protect the actual stock instruments,
they make the mirror image of the argument that you're making, which is that the Equal and Ratable Covenant mentions restricted subsidiaries only. And so therefore, you're rendering that provision a nullity by your interpretation.
Respectfully, Your Honor, it mentions restricted subsidiary, but well before that, it talks about Embark, right? It says the company, which means Embark, will not create, suffer to be created or to exist, right? So Embark is absolutely covered by the Equal and Ratable Clause. It is the entity that issued our notes. And by that virtue, before even looking at the restricted subsidiary, which by the way is subjected to additional limitations, there's no doubt about that, but we don't need to look at that. We look at what binds Embark. And Embark's asset, again, is its equity and the equity value that it holds.
Counsel, what are we to make of the prospectus? And if we're making something of the prospectus, does that mean that there's an issue of fact because we're looking at extrinsic evidence to the contract?
Your Honor, as we argued below, we believe the definition of property by itself is clear. To the extent there's other things in the indenture that create ambiguity, I guess you can go back down and
I mean, the prospectus, to me, is pretty clear. Quote, we will be a holding company and our subsidiaries will have no obligations to the holders of the notes. So that sounds kind of bad for you.
Agreed, Your Honor, and the subsidiaries don't have an obligation. Let me just be clear. The subsidiaries are not guarantors, right? And the reason why they don't have to be guarantors is because at the time the bonds are issued, there's no debt sitting in subsidiaries. Every dollar of value of these very, very valuable operations and subsidiaries is for the benefit of the parent, for Embark, right? And the protection to avoid debt being put on in a way that soaks up that value is the equal and ratable clause. And here we are enforcing the equal and ratable clause that was intended to prevent that equity value from being dissipated.
Thank you, counsel. You have time in rebuttal.
Thank you.
Please.
I please the court, Kristen Lovett on behalf of respondent. The Supreme Court was right when it held that, quote, the covenant unambiguously applies to Embark and its restricted subsidiaries only, and that the note holder's attempt to expand the covenant's reach to unrestricted subsidiaries through an overbroad reading of property and lien is unpersuasive, and that's at page 20 of the record. Appellant's theory is divorced from the text of the covenant. The covenant plainly forbids liens on Embark's property and that of its restricted subsidiaries only, and to expand the covenant to also reach the property of unrestricted subsidiaries would render those limitations meaningless. In fact, it would render the entire idea of a restricted subsidiary meaningless, because the only reason a subset of subsidiaries are defined in the indenture as restricted is to include them within the covenant. They appear nowhere else within the substantive provisions of the indenture. So clearly the drafters went out of their way to define a subset of...
Is there any other provision in the indenture that would create additional duties on behalf of the restricted subsidiary?
No, Your Honor, no. They are mentioned, I think, in the definition of a sales and leaseback transaction, but that also is relevant just to the...
It's only the allocated basket amount section that you...
Yes.
Where they are mentioned in
Yes,
this way.
which is also, again, is a carve-out from the covenant.
What about their argument that you're just denuding Embark of all assets? Or not you, but I mean, in other words, that your interpretation denudes Embark of any assets to pay back the note holders?
Your Honor, the question here is whether there is a lien on Embark's property, because that is the only thing that the covenant restricts. And a lien is a very specific thing. It's defined in the indenture as a preferential arrangement with respect to property. And to fall within the covenant, it has to be with respect to Embark's property or the property of the restricted subsidiaries. As to my friend's arguments about the economic...
But still, what you're saying, this is drawn up in a way which allows Embark to just denude itself of all its value and not be in a position to pay back these note holders.
Your Honor, it is drawn in a way to have a very narrow covenant with respect to the restricted subsidiary. And the appellants, who are sophisticated hedge funds, understood this when they bought the notes in 2006 as unsecured note holders. It was clear at the time, and appellants don't dispute that Embark was a holding company with no operating assets, whose entire value depended on the capital stock it held in its subsidiaries.
And the prospectus made it very clear, even on the cover page, that the notes will effectively rank junior to all indebtedness and other liabilities of Embark's subsidiary. So that sort of was a pretty obvious alert that they were going to be down the chain there, wasn't it?
Your Honor, I absolutely agree. I think that everything was clear and that the appellants went in clear-eyed into what they were getting themselves into. And of course, they are unsecured creditors. And to be clear, they are still getting paid interest monthly. So these dire economic consequences have not taken place. They would only take place if there was an actual default on the notes, if Embark went into financial distress and liquidation, sold all of the capital stock it holds in its subsidiaries, and distributed to...
The notes are due in 2036, right?
Yes, Your Honor.
We don't know if they're going to take a bath. That's your point.
Yes, exactly. We don't know what's going to happen, and the economic consequences have not happened.
Counsel indicated at some point that they sent some type of default notice to you. When was that, and what was specifically did that relate to?
So, Your Honor, the financing parties issued a press release prior to closing October 2022. At that point, appellants counsel sent a notice raising a single objection, and that was to the unkept guarantees provided by the restricted subsidiary. So they only singled out the restricted subsidiary at that point. The financing parties turned around, capped the guarantees at the allowed basket amount because they wanted just things to go smoothly, didn't want to hold up. And then 2 months after closing, for the first time, appellants counsel sends a draft notice of default raising this entirely new theory, which they now say is obvious from the face of the indenture, and yet for some reason they did not raise prior to closing, despite the fact that there was a press release describing that the unrestricted subsidiaries would be issuing uncapped guarantees and liens, and yet that was not raised at all prior to closing. Suddenly, they spent some more time, came up with a new theory as to why this transaction was bad, and this entire theory. And just to put a point in it, the appellants are as of the litigation represented 15% of the note holders, a minority of the note holders. No one else has shown up. The Supreme Court actually required a notification to the other note holders to allow them to show up in the Article 77 proceeding. No other note holder has shown up to stand along with this theory, even though it is supposedly crystal clear from the face of the indenture.
So you would agree, I'm assuming you agree with the judge's, Justice Maisley's interpretation of equity value, that it's not property.
Absolutely, Your Honor.
And that generally equity is the difference between the assets and liability. It's a value,
Yes.
correct? It's not the shares, it's not the capital stock, correct?
Yes, yes. And I think it's troubling that we actually don't have yet a clear definition from appellants as to what they think equity value is, because we think it could be, as Judge Maisley said, the difference in value between assets and liabilities, or it could be the market price of capital stock. Either way, neither of those two things are property. You can sell assets. You don't sell the difference between assets and liabilities on a balance sheet. You sell capital stock. You don't sell the market price of capital stock. Value is an attribute of property. It's why you buy things, but it's not an actual property itself. If there's no further questions, I'm happy to rest in our papers.
Thank you, Counsel.
Thank you.
To the panel's question with respect to the prospectus, it is true, the prospectus identified the fact that these notes are going to rank junior to the debt subsidiaries. But here's the key that I think we need to flag. In connection with the leveraged buyout, these subsidiaries took on $5.5 billion worth of debt at Embark's doing, but that value didn't sit with them. That $5.5 billion went to subsidize the equity check that Apollo paid to buy these assets. The $5.5 billion never sat at the subsidiaries, never went to Embark. It immediately left the system. And why does this matter? It matters because it's not just an issue of having debt that sits at the subs. It's the fact that that debt that sits at the subs that yielded no proceeds for the entities obligated to repay it devastated the equity value that our borrower has in these subsidiaries.
Doesn't that often happen in these leverage buyouts?
I'm sorry, Your Honor?
Doesn't that often happen with the leverage buyouts, that there's a lot of debt that's assumed and things moved around and equity moved around?
Absolutely, Your Honor, but here's what's unique here. The Embark notes existed before that leverage buyout. They could have been satisfied and taken out in connection with a leverage buyout. When Apollo decided not to do so, it incurred the risk of complying with what this indenture provides, and that's the equal and ratable clause, which is the central protection accorded to these note holders, which assured them that on a go-forward basis, that if any new debt came in a way that harmed the property of Embark, that they would get it on an equal and ratable basis to whatever that new debt is. And that didn't happen here. And that's what gives rise to the breach of contract here and to the default itself.
Thank you, Counsel. Anything else? Any other questions? Thank you both.
Thank you.
Your papers were excellent.
And thanks for the charts, too.
Yeah. Trocom Construction, the City of New York, Consolidated Edison and Empire City. Please.
Good afternoon, Your Honors. Victor Rivera, Jr., R&R Legal Advisors, LLC, for the appellant.
So you guys admit that you did not comply with the strict terms of the notice of claim requirements, and you're just saying essentially that they had actual notice, the city and the other two entities.
I think what we're saying, Your Honor, is that we complied with the contract notice provisions to the best of our ability under the circumstances. I apologize.
Okay.
When you're
Well, did what I couldn't figure out, did the city put a gun to your client's head when they decided to join phase one onto your phase two, which created problems for you?
Essentially, what they did, Your Honor, was say that you need to take this over, because we were the only contractor at the time that would have been able to take it over without any kind of significant delay. Trocom had done work for the city that was like this before. It was familiar with the types of things that needed to be done. What it was not afforded an opportunity to do, Your Honor, was to rebid or to look at the bid that it had previously submitted, which was only for surface work, and look at it in the context of the new subterranean excavation work that was going to be required under the Phase 1. So the net effect of that was on day one, we ended up on the job behind, being told that they were ready to proceed and being told that the site access was being denied because the Phase 1 contractor had not completed its work. None of this is denied, really, by any of the parties. The project was fraught with delays from beginning all the way to the end.
Well, didn't they accommodate you by giving you a whole year, or almost 2 years to complete the project from the original end date?
Well, that is part of the...
Wasn't that an understanding when you put in, oh, we're overwhelmed and we need more time, et cetera? The city gave it to you.
There is that, Your Honor, but there are provisions that allow, and there's case law that allows for the contractor to seek additional damages as they fall within the if they fall within the ambit of the exceptions to some of the rules. In this instance, we believe that we did. Again, one of the things with respect
They say that even if informal notice was enough, that the informal notice that your client provided was insufficiently detailed, didn't have enough detail about how much money you were out, how much more time it would take, just didn't have enough meat on it, even if you went with an informal process, which they're not agreeing to.
Yeah. I'm sorry, Your Honor.
That's okay.
With respect to that, what we would say is that we have had experience. Trocom's had experience, and I think the panel has had experience. Virtually every public contractor has had experience with these issues. Right. But one of the things that happened here was that to the extent that we were on a day-to-day basis confronting new issues, and I think
but
Mr.
You've
Santoro...
got this 45-day notice requirement. So you're suffering losses because of delays. I mean, why didn't you put in a formal notice of claim?
Well, we did eventually at the end of the project when everything was done.
But too late.
Well, I don't know about that, Your Honor. There were over 2,000 specific notices that were provided over the course of the project. They were provided in various forms. To the extent that damages were not set forth, Mr. Santoro, who was the project manager, said that because of the way the project was administered, he couldn't really tell you what it was going to cost. He couldn't really tell you how much the delays were going to be. And that was because the delays, which were purely within the province of the city and its utility partners, it was their delay to resolve. And
So how did you comply with 11.12 of the contract?
To the extent that we're talking about one of the contract, Your Honor, what we did was we provided significant, again, in the context of three different ways. There was a delay log that was presented at progress meetings. There were 2-week look-aheads.
Did you put in amounts of such damages?
Again, Mr. Santoro testified that at the time that those notices were given, he couldn't specify what the amounts would be because at the time, he would show up and the next day they would tell him there was something else that he had to do. And no one was giving him information with regard to how long a delay was going to take. So the formulation of that was saved to the end when it was more readily apparent.
Thank you, Counsel. You have time, rebuttal. We'll hear from the city next.
May it please the court, Jeremy Schwader for the City of New York. I think there's a lot of things I could say. I'm just going to start by saying notice of delay is very different than notice of delayed damages. And that is, I think we have an admission here that there was never notice of delayed damages. I also want to bring up that...
Counsel, what about their argument? I think in their brief they say the city barked orders at Trocom, and so they just were never able to catch up.
So I want to address that. So this is an argument, of course, that's being raised for the first time on appeal, that the city took some sort of affirmative action that prevented them from providing notice. That's what they're arguing now, affirmative actions that prevented them. That's not what they argued below. Below they argued, well, the city had notice and there was no prejudice. So if they're going to come in and say there are affirmative actions, well, then we should have had an opportunity to say, well, how exactly did we prevent you from providing notice of damages when you've provided us so many things that you've talked about that talk about all the delays that were out there? Why couldn't you provide us with notices of the damage?
What about his testifying that because there was so much going on and from day to day to day that they couldn't really figure out initially all the time what the amount of the damages were?
Then they could have asked for an extension, and they had every opportunity for ask for an extension. They've never explained why they didn't do so. That was the ability to do that was there. The contract says you could, and you might get an extension. So if they can say, come in and say, we just can't put together the numbers right now, but we're going to have damages from this. We need an extension to give you the details. That might be a different case, but that's not where we are. And I think to come in now and say you took affirmative actions that prevented us from providing you what the contract required, to come in at appeal when we haven't had a chance to probe why that could possibly be the case here, when it clearly isn't the case. They could have provided some notice.
What about counsel's statement that they gave notice when they finished, when they ascertained what actually was?
Sure. So I think they're referring to the notice of claim, which I'll refer you to page 1956 of the record, which has 12 generalized categories of damages. That's it. There is no specific notice in there about exactly each claim for damages. It took us many, many years of litigation, 6 years of litigation, and then only after we moved for summary judgment did the city actually get some sort of breakdown that specified what the damages were, how they were apportioned. And the Supreme Court understood that and mentioned that the fact that they couldn't even put this together in some coherent way for so long showed how they weren't doing what the contract required.
So as I understand it from your position, is that 11.1.1 and 11.1.2, the first one being a shorter time period and a little longer time period, is really a condition precedent, separate from the statutory notice of claim that they filed against the city after.
Oh, absolutely, absolutely. That's and the notice of claim doesn't have any sort of breakdown of the damages and the proof or anything like that. I mean, they understood what they were required to do. They entered into a bidding. They did this. And I know my time is up. I'll just make two other quick points. They also didn't comply with the comptroller's request here. That was another ground that Supreme Court relied on. I think that's another ground that's a valid reason for the granting of summary judgment. And then they've also waived any argument having to do with the non-delay claims by not bringing them up in their opening brief. Thank you, Your Honors.
Good afternoon, Megan Rowe on behalf of Respondent Defendant, Consolidated Edison Company of New York. May it please the court, I'll say that we agree with everything the city just said with respect to the condition
You
precedent.
should probably focus on the third-party beneficiary status.
Yes. My next point is that this argument applies equally to Con Edison as a third-party beneficiary of the contract. As recognized in the summary judgment order, there's express language to this effect in Article 3.6 of Addendum 6, which states that utilities are third-party beneficiaries of the contract and are entitled to rely upon and enforce any and all terms and conditions. A determination on this condition precedent issue and that the delay claims have been waived is really all that's needed to affirm here. I do just want to refer the court to our brief. We do have other points that we've raised in the event that the court goes beyond the condition precedent issue. There's separate reasons for affirming the order that were not addressed in the order. Two of those points were addressed by this court in the 2019 Trocom versus City of New York case, which dealt with additional restrictions on delay damages. And also we've noted that Trocom failed to meet its evidentiary burden to show delays that slowed the project completion date by Con Edison, and also have failed to identify why they should receive duplicative damages for non-delay claims between Con Edison and the city. Unless there's any questions from the panel, we do just rest on our brief.
Thank you, Counsel.
Thank you.
Good afternoon. May it please the court. David Gooderl from Leader Burkon, Kaleo, and Silverstein on behalf of Respondent Empire City Subway. I would also like to reiterate that we agree with the points raised by the city and Con Ed. The only point that I would like to raise is that if the court does get beyond the condition precedent issue and the notice provisions in Article 11, there's a separate waiver in JB 900, which is one of the specifications, where ECS paid the majority of its money to Trocom in this matter, that the acceptance of money under the JB 900 specification contemplates all delay damages, and in addition to that, the acceptance creates a waiver of any delay damage claims, and that is a slightly different thing from what is argued before, but is also another grounds on which Judge Billings could be affirmed, and that in Trocom's reply, it tries to argue that the JB 900 specification doesn't contemplate time where Trocom is waiting to be told how to proceed, and I don't believe that that makes any sense in the context of JB 900, which covers lack of efficiency, mobilization, remobilization, demobilization, and anything else that is a delay damage and idle time. So they're seeking to create an exception that would swallow the rule there. To the extent there are any questions, I'm happy to answer them. Otherwise, I will sit down.
Thank you, Counsel.
Thank you, Your Honor. A few points that were raised. Initially, there was a discussion about the information that was provided. The information that was provided, and which was denigrated before, included, two requests for extensions of time. There were 166 separately detailed delays in those. And again, with respect to the sufficiency of the information that was provided, I think there was enough there for anybody to reasonably understand what was going on. To the extent that they're specifically talking about damages, excuse me, to the extent that they are talking about the damage issue, we believe that the information was provided over the course of the litigation. We also would like to point out, with respect to the JB provisions that were just referred to, I think we raised the issue in the brief that the language is inconsistent as between them, and that we fall within one of the exceptions. I don't believe that prevents us or our client from recovering on that ground. The bottom line for us, Your Honor, is that what we see here is a competition between two important public policies. One is protection of the public fisc. We all know that. That is one of the things that definitely is important here. An equally important thing is that for public contractors to get paid for the work that they do. There's no issue here with respect to the quality of the work that they perform. There's no issue here that they did everything that they were asked to do. And again, with that little point, and I know my time is up, but I just want to wrap it up real quick. I know there was a discussion about what had been raised below. Throughout the course of this litigation, there has always been an argument that the complexity of the job was preventing Trocom from performing. So I'll leave that at that, and I'll stand on the rest of the arguments in the brief.
Thank you, Counsel. Thank you all.
Thank you, Your Honor.
Simon, before World Trade Center.
May it please the court, Jessica Smith for the World Trade Center defendants. Our argument for dismissal of the Labor Law 241 claim is simply that the statute does not apply Here, plaintiffs assigned work at the time of the accident did not involve a risk from an elevation differential. The compaction process was entirely within the control and responsibility.
I mean, you know, Lucas is a case that you have to grapple with, of course, which where a bunch of window frames fell over on someone and they were lying on the ground. So how is the A-frame that was holding these windows different?
So
is it simply the kinetic force of something coming sideways to knock them down? Is that the difference? Or?
Well, that's part of it. So part of our argument is, in fact, that the force of the glass coming out horizontally, shooting out from the compactor, is actually what caused the car to tip over. And because that's force is not a force of gravity, therefore the statute simply does not apply, and it's not akin to some of the other cases that you're mentioning. In addition to that, we also have the argument that it doesn't involve an elevation hazard simply because plaintiff's work did not require him to crouch behind the A-frame, behind the compactor.
Is that an issue of comparable negligence, though?
It is not, because I can refer the court to the Ortiz case, which is discussed in detail in our brief. It essentially says that there, the plaintiff Ortiz must establish that he stood on or near the ledge at the top of the dumpster because it was necessary to do so in order to carry out the task he had been given. So that directive tells us that here, plaintiff and us on summary judgment had to establish that there was no work-related reason for plaintiff to be present behind the A-frame cart. And no one says that there's
Actually, here, everyone is on ground level, aren't they?
Everyone is on ground level, and all he needed to do at the time of the accident was stand off to the side.
I mean, both the driver of the truck, the compactor truck, the Royal Waste employee, and the supervisor were also both there at the time that this accident happened, right?
They were both there. No one instructed him to crouch behind the cart. All his work involved loading these pieces into the back of the hopper. Once he did that, his work essentially
But
ended.
actually, as you look at the video, it's really very hard to understand crouching behind the very area from which the projectile is going to be spinning out.
Your Honor,
behind an A-frame that had more glass on it.
Except he did it once before. This was the second time they were loaded into the truck, right?
Right, so he knew what was going to happen. And actually what's important about this is there's no emergency situation that prompted him to duck behind the cart. A, he knew it was going to happen, and B, the driver...
Does it matter that his supervisor was there and observed him one time crouching behind the A-frame with the glass on it, and nothing happened? But should he have at that point said, hey, Mr. Simon, maybe come back where I am, let's get in a safer spot?
So it's actually not relevant to the arguments we raised here because we're not arguing sole proximate cause. What we're arguing is that the statute doesn't apply because this assigned work at the time did not involve...
So Supreme Court left this as an issue of fact, right? What is the issue of fact that's to be tried?
Essentially, they said it was a division of responsibility, and they relied, and that's on the negligence issues. There were issues as to the division of responsibility. The other...
In the 241, Supreme Court denied summary judgment.
Correct, and they...
left this for a trial.
They relied on Walensky and essentially was saying that there were, issues of fact as to whether a safety device was required.
So as to 241, what are you going to be trying it? What would you be trying at Supreme Court?
Essentially whether there was a safety device of the type understood by the statute that was required for this.
So would that be securing the cart of which the panels were resting before they were being
essentially that's
secure? Is that the safety device that they're claiming?
That's what my understanding of the decision is. We don't believe that obviously that's appropriate. We think that it should have been dismissal, A, because of what we said previously, and then additionally, this A-frame cart is not the type of device that the statute envisioned. It's not designed to protect from a gravity hazard. It's designed to transport materials, and that's what distinguishes this case from a lot of the other cases this court has decided.
Well, isn't it a precisely correct device to use to transport materials?
Yes, and no one said that there were any issues with it. The A-frame cart functioned appropriately. The supervisor agrees, plaintiffs agrees. It's just not intended to be used as a shield to protect plaintiff from
shooting glass. So it functioned appropriately for its intended purpose here to transport materials.
Could the materials have been strapped down? Could they have been secured in some way that might have prevented the shattering or the tipping?
There is no device that could have prevented it from tipping. This is something that, because it was caused by the force would have hit the cart. The cart fell wholesale with the glass on it. It's not something where the glass got knocked off of the cart and then fell onto plaintiff, which is the big distinguishing factor here. It's the cart together with the glass. So there was nothing that could have been secured the glass to the cart. It wouldn't have mattered, because still then you would have the horizontal force launching forward due to the compactor hitting those glass panels and still knocking it over. So there was nothing that could have been done here. So there are no issues of fact, and everything, all of those claims should have been dismissed. And I see that my time is up, so I will address
Time to
them.
rebuttal as well. Thank you.
Good afternoon, Your Honors. May it please the court, Zach Perisman for the plaintiff, Juan Simon. Juan Simon is entitled to summary judgment under Labor Law 240 sub 1 because we have a stationary...
Counsel, just at the outset, can we clarify, you're not asserting a 241 sub 6 claim anymore, right?
That's correct. Yeah, we're not moving for summary judgment. Correct. That's correct.
Okay, so you heard your colleague say that the A-frame cart was not a safety device. That's within the contemplation of 240 sub 1. What about that?
That's correct, Your Honor. And what was going on was plaintiff was exposed to an elevation-related risk because you have an unsecured A-frame cart. A safety device would have been securing the cart. It would have been the device that they would have employed, the braces, the tie-downs.
Explain to me, we've all seen the video and the stills, but the video is, very clear. What was the safety device that could have been used in this case? I've been trying to think of that. So if
Your Honor, and I'm happy Justice Moulton brought up the Lucas case because I didn't
Yes.
bring enough copies to fill out the little sheet out there.
Yeah, we have
I
them.
saw that one that Justice Friedman was on the panel for. I liken that to, you could liken this to any of the other cases where you have materials that weighed a significant amount that were on the same level of plaintiff but toppled over onto plaintiff. It's the same question. What could be used to brace or secure those materials? At the end of the day, it's not plaintiff's obligation to figure out what safety device is supposed to be provided to protect himself.
No, I agree with you. The thing is, what was actually going on here is he was putting the glass, Mr. Simon was putting the glass in the back of the compactor truck to get destroyed, right? To get,
Compacted.
Compacted, right. That's what you use a compactor truck for. So they couldn't fit all of the glass into the compactor truck. As a matter of fact, I think the driver said, you put in enough, guy, step away. And the supervisor said, no, keep putting it in. But not all of it got in. We know that. So here he has something that he's pushing the glass in to move it, to put it into the compactor truck. Why would you secure what you're about ready to put into the compactor truck? It doesn't make sense to me.
Well, Your Honor, I think the fact that, as Justice Moulton mentioned, that they had just done this one second ago, now they aren't just using an A-frame cart to transport materials. It would be correct if that's what they were using it for. They were using it.
In other words, because the supervisor saw your client hiding, crouching behind it, and didn't say anything, that means it's deemed a safety device to shield from shooting glass?
Because the supervisor saw that what was going on was the A-frame cart was being left there and used as a storage device that had wheels on it and knew that there was glass spraying out of the back of the truck. And when plaintiff requested a safer means
from the cart to the truck. How do you call that a storage device? I mean, the cart is doing exactly what it was meant to be doing, which is to move these glass panes.
Under Buckley, Your Honor, this court has said what is essential to a conclusion that an object requires securing is that it present a foreseeable elevation risk in light of the work being undertaken. In Jordan, this court held that it was foreseeable that during hoisting, a crane could strike a stack of rails, causing it to fall. Kevin Creedon had just stood by there and witnessed the glass spray out of the back of that truck right in the direction of the A-frame cart. Plaintiff at that point requested to break the glass into smaller pieces so it could fit in the compactor and wouldn't be sticking out and spray all over. Instead, Creedon forced him to go ahead and continue doing this, knowing that the cart was closer to the back of the truck at this time, never instructed him to move away, never enforced an exclusion zone. So plaintiff did what he deemed at that point was a safe reaction to the inherently dangerous situation he was put in by Kevin Creedon, by his boss. They were the ones charged with his safety.
Was there any reason he couldn't move away? Like,
well,
rather than being right behind that truck?
Your Honor, hindsight is 20/20. And when we look at this now and we say that maybe he didn't make the most ideal decision to crouch behind rather than move away.
It's hard to call this not making the most ideal decision. I know the defendant is not now defending on sole proximate cause, but you know, when you look at it and having seen it before, to crouch behind the very area from which the glass is spitting out seems like, how do you make such a decision? It's, you know, it's not like an ideal decision. It sort of seems more like a sole proximate cause type of situation.
Well, Your Honor, I think this case exemplifies the exact reason why plaintiffs' workers are not left to fend for themselves for their own safety on the site, and why he had his supervisor standing right there who was charged with his own safety. His supervisor could have made sure that they didn't close that compactor before he moved out of the way. His supervisor could have made sure that the cart was secured since he knew it was closer and the glass was spraying
does it take a supervisor to know not to stand behind where the glass is spitting out from?
Well, Your Honor, in fairness, defendants can't have it both ways. They're saying plaintiff put himself in harm's way by crouching behind the cart, but they don't want to accept responsibility for their duty to foresee the same thing?
Counsel, in the brief, your friend raised the issue that this is not gravity related because the only reason that cart fell was the kinetic force or energy of the glass shooting out. That's not gravity. That's a separate force that caused that cart to fall. What's your answer to that?
In all of this court's horizontal force cases, the plaintiff was struck by the propelled object itself. This case is no different than the plywood that blew over due to a gust of wind that Justice Kapnick was on the panel for. It's an external force that, at the end of the day, plaintiff was not struck by propelled debris.
An external force which is not gravity related.
Well, Your Honor, if gravity wasn't involved in this accident, the A-frame cart would have bounced right back up. But it didn't, because regardless of the fact of whether it was struck by a gust of wind or by glass spraying out of a truck, it was destabilized and fell over as a result of gravity.
Thank you, counsel. You have time to rebuttal.
Okay, thank you.
Good afternoon. My name is C. Briggs Johnson for the appellant respondent Royal Waste, and I just want to touch briefly on what my adversaries and co-counsel talked about here, and I think to Justice Kapnick's point, the Salazar case, contrary to the objectives of the work, and you know, the glass is, there's plenty of cases that talk about when the goal of the work is to demolish, to get rid of stuff. You know, you don't secure something that's in the process of getting destroyed, right? So your point being, you're not supposed to secure the glass is supposed to go into the compactor, right? There's plenty of appellate division case law on that. And my adversary talks about the Buckley case and the Jordan case and about foreseeability, right? It's not foreseeable, you know, that when the work is ongoing, they're bringing the glass partitions down to put them in the compactor. It's not foreseeable that this glass is going to shoot out sideways. That's not what the work is about. It was only foreseeable when Mr. Creedon got on the phone and said, overload this compactor, right? So it's not foreseeability in terms of plaintiff's assigned task at the time of the accident.
Now, you are also arguing, other than the
Yes.
240 subsection 1, that you are not a statutory defendant in
Yes.
this case under the labor law, if we were to find that there was a
And
labor
that's
law.
my next point, correct. So I think, you know, it's clear on this record, there's a couple of things I think that take us outside the ambit of the labor law. Number one is that we're on the project at the end to remove debris, right? We're not a subcontractor doing any work on the contract, on the project.
The contract was with Holt, who is plaintiff's employer, right?
It's a telephone call. It's not even a contract.
contract.
Right. There's no written contract saying, when you look at the statutory agent cases, it's authority over plaintiff's work, or, and there's a written contract that says, you're the HVAC contractor.
There's no written contract here.
There's nothing, right? And there's just a phone call, hey, come to the project, take the debris out, right? That's the first thing. So there's no contract giving us any authority or control over plaintiff's work. The second thing, and I think the most important thing too, is we have literally nothing to do with the debris being removed from the project. We're providing the truck. They're loading the truck.
And Mr. Perez actually was overruled by Mr. Creedon, right?
He was berated, and that's plaintiff's testimony. And that's, that is my client's testimony as well. Our guy actually said, listen, this is full.
Your guy is the driver.
It's the driver, Perez. He's saying, this is full, we gotta go. Plaintiff's like, okay, let me call my supervisor. Supervisor comes down screaming, load it, load it, load it, load it. And he also says, get to the side of the truck.
Your guy said.
Yeah. So he went to the side of the truck, right? Supervisor Creedon,
He went to the other side of the truck.
Right, the nefarious guy who wants all this glass to be compacted says, get to the side of the truck. Then plaintiff says, let me stand behind the A-frame cart and see what happens here. So while we didn't brief the sole proximate cause defense, that's going to get in front of a jury. Let's see what you think about that. But also, it's the only thing my client did here was at the direction of the general contractor, right? And we didn't want to do this, was press the compactor, okay? Demolish the glass, and he doesn't want to do it, right? So
Are there claims against your client for just straight negligence, common law negligence?
There's labor law 200.
200, and
there's common law indemnity.
And that's still, well, forget about the common law indemnity.
Yes.
The negligence case against plaintiff against you, plaintiff against you, is still in there.
Correct.
What's the indemnification issue between you and the?
So the argument from my adversary is because we pressed the compactor, we're negligent, and they're moving to dismiss the labor law 200 claims because it's a means and methods case, right?
Well, you have no evidence
of their negligence.
Their negligence, correct?
Right.
So your cross-claim for common law indemnification against them, gone, right?
Yeah, if it's
You didn't
still
really
alive, it's
oppose
gone
that,
now.
did you?
Excuse me?
You didn't oppose that, did
I
you?
don't think so.
I don't think
or if I did, it was in a footnote.
And you certainly don't have contractual indemnification.
I don't have a contract, which is why I'm not a labor law defendant.
So there is a negligence claim
There is
against
a
you
negligence-
besides labor law
Right,
200.
but I'm a subcontractor, right? So under Espinal, I'd have to launch an instrument of harm, right? The question is, me being excoriated by a GC to do something I recommended not doing and pressing a compactor button, did I cause the accident? I mean, listen, there's causation and proximate causation, right? How far are we willing to go in terms of legal causation against a subcontractor?
Would that be an issue of fact for trial?
Well, I mean, it can be an issue of fact for trial, but I guess the point I'm trying to make is, we said we don't want to overload this. We said move to the side, Yeah,
but you didn't have to push the button until the whole area was clear, right?
I didn't have to push the button, but I guess my point is pushing the button, an issue of fact for the jury. My argument is that it's not, but at the very least, there would be an issue of fact on those claims, and of course, the common law indemnification claims, they would have to prove I'm negligent, so at best, that's conditional. If there's not anything else, I'm going to rest on the briefs.
Thank you, counsel.
Thank you.
So I'm just going to start with addressing Royal first. I want to make it very clear that everyone is not in agreement that, the driver warned plaintiff. Plaintiff and Creedon both said they didn't hear it. The driver says he did say it, so that is not, it's being presented like everyone agrees on that point, and that's not the case. In addition, as to the instruction of Creedon telling the driver to keep loading it. Now, the driver doesn't have to listen to Creedon. Okay, he's testified. He's in control of the truck. This is entirely his domain. He decides
but
when.
Creedon did. I mean, is it contested that Creedon called Mr. Perez's supervisor?
Creedon testified that he didn't recall any of these conversations.
Where does that come in then? That alleged fact.
Somebody
said it.
I don't really think it does, honestly, because he's in control of the truck, right? So that's what he admits. He received the safety training. He knew what to do. He was the only one who could hit the button. It was his responsibility to make sure no one was clear. And what hasn't been talked about is he also had the ability to stop the compaction process. So we can see in the video that this plaintiff is clearly in his eye line. So he has the ability to stop the truck, and he doesn't do that. So based upon his admissions that he had the responsibility, and what occurred here, I think it's clear that there is a negligence against Royal. And as you mentioned, there's no evidence of negligence on the part of the ownership defendants here. So I think if the whole case isn't dismissed, then we should have common law indemnity against Royal. In addition, we also ask for attorney's fees for the defense, which is addressed in the papers. So I just want to go also to mention the Espinal issue. Espinal was not raised below. It shouldn't be raised here. Also, this court's case in Debrino discussed that if you're in privity between an employer and the general contractor or a contractor, Espinal simply does not apply because you're not outside the contract. So
thank you, counsel.
Thank you.
Because I ran out of time, Your Honors, I just want to briefly address Royal, just very briefly, because I don't want to waste too much time on that. We are asking the court to modify the order below and grant summary judgment on the Labor Law 200 and common law negligence claims against Royal, for the simple fact that the driver completely neglected his responsibility to make sure that plaintiff was out of the way before he engaged the compactor. He testified himself that he stopped looking, regardless of anything he said about a warning, and obviously that's a question. He never gave a second warning before it was engaged the second time, and he said he is supposed to make sure that everyone is out of the way before he engages the compactor. He stopped looking, and he says if he had looked, he would have seen plaintiff. For those reasons, and because they had exclusive control over the injury-producing work, they are a Labor Law 200 defendant, and we should get summary judgment against them, against Royal Waste. The Salazar issue that was brought up. The A-frame itself was not being destroyed. The A-frame itself was merely either a storage device or a device being used to transport the materials. There was nothing preventing the A-frame itself from being tied down. It's a device on wheels with potentially over 1,000 pounds of glass in it. There was nothing to prevent that from being secured. And in fact, it wouldn't have prevented the work or impeded the work, like Salazar says. It would have made the work safer. So I don't think Salazar applies here because there was nothing preventing them from making sure that the A-frame didn't fall over or making sure that an exclusion zone was enforced when the compactor was being operated. Now, Your Honors, I just, in conclusion, I understand this is not a typical ladder fall or scaffold fall case. We've all seen the video. It's a split-second chain reaction. It's jarring. But we're not here to, when we're applying Labor Law 240, it's about principles. It's not about matching the facts of this case to a video in another case or the facts in another case. And the reality is, I am sure that in some of the other cases that Labor Law 240 has been granted in this department, if we had a video and we saw how fast it might have happened, I don't know if the decisions would have been different. But the reality is we do have a video here. And I think at the end of the day, we have to think about what actually happened, which is you have an unsecured, heavy object that fell over and toppled onto plaintiff as a result of gravity. This court's law is clear that that is a Labor Law 240 violation.
Thank you, counsel.
Thank you.
Okay, thank you all. People versus Harold Carter. Please.
May it please the court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Harold Carter. The evidence of the SORA hearing established that Mr. Carter met the complainant at a social gathering, they communicated via phone for approximately 2 months, and then met and engaged in sexual activity. The departments of the Appellate Division, most notably the 4th Department in People v. Perez and the 3rd Department in People v. Birch, both cited in our briefs, have held that facts like this are insufficient to prove by clear and convincing evidence that the defendant established or promoted the relationship for the purpose of victimization. The SORA court thus erred in assessing 20 points for Factor 7, and this court should modify Mr. Carter's risk level to level 1. I think it's important to note a couple of things. First is that Factor 7 in the board's commentary and the guidelines makes clear that this is essentially about tracking risk of recidivism, which is why that factor focuses not on how serious the offense was, because we can all acknowledge that offenses like these are very serious, but rather on whether it is the sort of case that tends to correlate with a higher level of recidivism.
SORA is all about recidivism. That's what we're focused on, not on further punishment.
Correct, Your Honor. And the board makes clear in their commentary about Factor 7 that it's because people who target strangers, who seek out strangers, are at a higher risk to recidivate than those who commit offenses against people whom they already know. And it's quite clear in this case that, I mean, the people conceded below, there's no allegation that Mr. Carter sought out the complainant. They met by happenstance.
Counsel, there's just so much evidence of grooming here. I don't see how you really have much to go on with respect to denying that.
So, I mean, Your Honor, I think what People v. Cook makes clear is that Factor 7 is also not about grooming. They quite explicitly say grooming is not sufficient to assess points under Factor 7. It is a very narrowly applied factor that is not focused on whether there was grooming. It is focused on whether there was a relationship that was established for the purpose of victimization.
Yeah, there's a fine line between those two things. I don't understand what you're talking about, to tell you the truth.
Well, it's the language from People v. Cook, Your Honor, so I'm just trying to be faithful to that. But I think the key here is that we know that they meet by happenstance. We know that at some point, it's not clear when, their conversations via phone turn sexual, and then at some point they meet up and engage in sexual activity. That's the fact pattern in Perez, it's the fact pattern in Birch, and the courts in both those cases.
Also, I mean, in the aftermath of the arrest, and he gave a pre-sentence interview, it seemed like your client was just not grappling with what happened at all. He was just rationalizing. So, what is that? How should we take that?
I don't think that really speaks to Factor 7, Your Honor. I think it would be more pertinent to acceptance of responsibility, which the people have never sought points for here. I don't think it really speaks to Factor 7. I'd also just note that the board itself, faced with the same facts that the prosecution relies on, did not assess points. And the People v. Cook, the Court of Appeals, again stressed that because the board is the entity that created and is responsible for implementing the guidelines, it's obviously not dispositive. The court makes the final determination. But that is entitled to some weight, that the board did not think these facts warranted the assessment of points under Factor 7. I think given that, given the gaps in the record regarding what happens between the time when they meet and when the actual offense occurs, I think it's just too similar to Perez and Birch, and the courts in both those cases were quite clear. There's just not enough here for clear and convincing evidence. There needs to be more detail speaking to the defendant's state of mind at the inception of the relationship when they meet in order to assess points under this factor. It's not...
Wasn't Perez, wasn't there only an 8-year age difference, and there had been no contact for many months before they had any contact, where in this case there was a 22-year age difference and contact that happened, from the moment they met to 2 months later when there was sexual intercourse?
May I answer?
Please.
Yeah.
So you're correct about the age difference in Perez. I'll note, though, that in Birch, there is a 21-year age difference, and I don't think either court suggested that alone was particularly dispositive. I don't know the exact time frame in Perez off the top of my head, but I think that the time frame in this case is consistent with other cases. We also cite People v. Peleas from the 2nd Department, where there's a 3-week gap, and the court still says that's just not enough without more evidence. So I think for that reason, there's just not enough evidence in this case.
Thank you, counsel. You have time, rebuttal.
Thank you.
Good afternoon, Your Honors. Jacob Marcus for the People. When defendant, a 36-year-old man, established a relationship with the victim, a 14-year-old girl, he leveraged his role as a youth counselor to gain and exploit her trust. He established communications with her over social media and mere weeks later solicited nude photos of the child. He started sending graphic images of himself, and then at 2 months drove across state lines to meet her to have sex in a public park. I think that squarely gets us to clear and convincing evidence for factor 7. Just to address a couple points that opposing counsel raised in their argument, we talked about faithfulness to the language of Cook. Where Cook describes where points aren't appropriate under factor 7, it describes redirection of close, long-standing relationships. This is not, because remember, in People v. Cook, this was the children, the victims were the children of defendants' friends that he had grown up with. He had known them for years, and then years into their relationship started grooming them and abused them. Here, there was no redirection of a close, pre-existing relationship. And then just to turn to Perez and Birch, which opposing counsel relies on, in Perez, there was a defendant met the victim and then started non-sexual communications months after meeting. In Birch, there was a 4-month relationship of non-sexual communication before defendant raped the victim. So in both of those cases, you have extended periods of time of a non-sexual, non-predatory relationship.
In fact, during the time period between the first meeting and August, the August date, there was building up. There was grooming.
That's correct, Your Honor. And not only was there grooming, but I think that extremely short time period between establishing the relationship, promoting it to a sexual one, and then having sex with an underage victim, that just bears as to defendant's intent, and it was enough to establish points. I'll just briefly address the departure issue. As Your Honor noted, I think defendant's statements in the PSR were very concerning. His attempts to minimize his own culpability, voiced responsibility onto the victim. So I think those are aggravating factors, and then weigh those against the only mitigating factors, employment and lack of criminal history, which are squarely accounted for by the RAI. The court properly used its discretion in declining that departure. So the people ask that you affirm.
Thank you, counsel.
I'd just like to briefly address the downward departure argument. As we explained in our brief, the court erred in concluding that the factors pointed to by Mr. Carter were already accounted for in the RAI, because factor 15 is only concerned with whether you have inappropriate employment, which is employment that gives you greater access to victims. It makes no distinction between appropriate employment and no employment. I mean, the vast majority of our clients, because they haven't been released yet, have no employment and are not scored under this factor. So the RAI doesn't take into account whether you in fact have appropriate, stable employment that, as the court below recognized that Mr. Carter had shown, a great deal of stability, but it erred in concluding that was already accounted for in the RAI. Because factor 15 simply doesn't speak to that, it was appropriate to consider for a downward departure, and we would urge the court to rule on that basis if it rejects our factor 7 argument. At a minimum, if it's not a factor that's not taken into account at all by the RAI, it is not taken into account to the degree that the record reflects, and so this court should still reach the issue. Thank you.
Thank you. Thank you both. Pisano versus Pisano.
Good afternoon, Your Honors. May it please the court. Matthew Schenker from Fox Rothschild for the respondent. The trial court's decision should be affirmed. I'd like to update the court that today there was a stipulation that was filed resolving the sanctions portion of the appeal. The appellant agreed to withdraw that aspect of the appeal. That has been resolved. That was the aspect of the trial court's decision that awarded sanctions for my client. So the appellant has agreed not to appeal that portion. And
I assume they're going to send something in and contact the clerk.
that was a stipulation was filed this afternoon.
Oh.
But a mere hours ago.
I guess we were here already.
I have a copy if Your Honors need it, but it was filed. Secondly, with respect to the court's factual finding that my client, Kathleen, is an owner of the shares appurtenant to the unit, that finding should be affirmed for two principal reasons. One, Philip Pisano, who is Paul's son from a prior marriage, lacks standing to challenge the ownership of the estate of the shares because he's a mere beneficiary of the estate, and under this court's decision in Rappaport versus Nye, that's 222 AD 3rd 415, that's a 2023 case, a beneficiary does not have standing to seek recovery of alleged estate property. Reason one. Reason two is that the affidavits of lost stock and lease signed by both Paul and Kathleen are in accordance with CPLR 4538 and thus are presumed valid. They can only be contradicted by proof so clear and convincing to amount to moral certainty. Not only has that not been shown, but Philip does not even address these points in his brief before this court. Other than that, I would rest on my papers for the balance of the arguments.
Thank you, counsel.
Thank you, Your Honors.
UKI Freedom, the Organization for the Defense of the Four Freedoms for Ukraine.
Good afternoon, Your Honors. Walter Drabenko for the appellant. Your Honor, on our appeals, we have two questions presented to the court. One was relating to the personal guarantee, and two was the denial of the use and occupancy under the Yellowstone injunction. The motions were pre-answer motions to appellant's counterclaims. So we believe that the lower court breached its, I guess, duty as well as discretion based
The
upon
question of a novation, so that's Mr. Lebedovich. Am I pronouncing his name correctly?
Correct, yeah, you're pronouncing it,
So a novation of his guarantee was accomplished. That's a matter of law.
Well, there is no novation because the original lease, the underlying lease in 2014, clearly states, and the guarantee says any subsequent assignment does not negate the guarantee that was signed with the original lease.
Except the 2017 assignment, which you don't challenge its authenticity and its execution. You challenge Mr. Kozarek's role in signing the 2018 modification to allow the speakeasy, but putting that aside, that clearly describes very different rights, that everything, including the guarantee, is assigned to St. Mark.
That doesn't make
all
any
their
sense.
obligations, even though the language of the original lease, the assignment document, the 2017 document, which is signed by the person who would otherwise want the original document to survive, makes clear that there's a change in responsibility. That's a classic novation.
No, it's not a classic novation because the guarantees that were signed for the original 2014 underlying lease clearly says, but for these guarantees, the landlord would not enter into a lease with these parties.
Yeah, I mean, I get that, except that that was 2014. 2017, the assignment and assumption of the lease that was signed says, and I have it right in front of me, a signer and landlord assigned to the assignee all of the assigner's rights, guarantees, title, and interest in the lease and the security deposit.
Well,
So that happened afterwards, so how can you, I mean, how can you
Let's
say?
think about what's being said there, Your Honors.
I assume it's
The landlord gets a guarantee from the tenant, and then the tenant on the subsequent assignment says, the landlord and the tenant allegedly agree that, oh, I'm giving you my guarantee back to the tenant. That's not the underlying consideration for the 2014 lease. How can you do that? The guarantee remains. It clearly on the face of the document, it states, no matter what happens subsequently, any subsequent assignment or changes of the lease, the guarantee remains.
Why doesn't just do it, assignor and landlord, which Judge Kapnick just read, assignor and landlord assigned to the assignee all of the assigner's rights, guarantees? Why does it speak of guarantees if it's not getting rid of that guarantee?
That language is irrelevant. It's a red herring because you can't assign a guarantee of a tenant to a tenant. And the underlying consideration for the 2014 lease are those two guarantees.
There may have been other ways of wording it, but Greg Lebedovitz is being taken out of his guarantee here.
With the 2014 lease, clearly says, and the document it says,
But
any
why are we
subsequent...
looking, why are we looking at the 2014 document?
Because
when
that's
there's a
the, that's the
2017
underlying
document?
consideration why the landlord entered into a lease with the tenant. The landlord entered into the lease with the tenant based upon two guarantees. And it clearly says in the 2014 lease that no subsequent amendments and/or changes.
But in 2017, the landlord is allowing a new tenant to come in, isn't it?
It's an alter ego of the original personal tenant, which is Greg and Jerry Lebedovich, which is the father and son operation. Okay, that's relating to the guarantee. The guarantee still remains. How can you take out the underlying consideration of the 2014 lease?
Counsel, you made that point several times now.
Yes.
Let me just ask you this question before you sit down. You have abandoned your tortious interference claim against Kaczurek?
No, we haven't, Your Honor.
Have not. In your reply, you seem to revive it, but you didn't say a boo about it in your initial brief, isn't that?
Your Honor, I don't want to put anything on the record relating to that, but I do understand it since the respondent raised it. I wanted to address it in my reply, and I do not agree with the lower court's decision that the court said it was
time barred.
It was not timely, and they didn't agree with the tolling provision of it.
Okay, thank you, counsel. You have time, rebuttal.
Thank you.
Yes.
Good afternoon, Your Honors. Daniel Gortz for Respondent UKI. Following up what Your Honor said, yeah, the assignment assumption is clear. You know, he wants to mince words that it said you can't assign. Well, you know what? It also says assumption, right? So yeah, when you assign the lease, right, then the guarantee doesn't go with it unless, of course, you include it, right? That was what the paragraph that he's talking about in the lease that says that, oh, if I assign the lease, right, then you know, the guarantee doesn't go with it. Yeah.
The assumptions, the next paragraph, which I didn't read, also says assignee assumes full responsibility for the lease as if assignee signed originally as tenant.
Absolutely. So that's exactly, that's a clear novation. I mean, they said it literally, paragraph 1, 3, 4. I mean, like the preamble says it. Like this is clearly, they were making it super clear.
But even in paragraph 3, the fact that later on in the paragraph it eliminates Jerry Lebedowitz's guarantee is indicative that the earlier portion of the paragraph is getting rid of Greg's guarantee.
Correct. That's exactly what happened. There was a guarantee for Jerry. That sentence clearly takes it away, says that that's gone. And the earlier sentence in that same paragraph, that takes out Greg. I mean, there's no other way to read it. Also, his brief totally tries some other tactic that he did not put before the Supreme Court.
The Yellowstone injunction did not have a provision for use and occupancy, correct?
That's correct.
And so your friend believed that he should be entitled to some use and occupancy, particularly when you're occupying the space and using it. Why do you think the motion court was correct, or granting UNO would be contrary to the status quo?
Of course. The obligation for rent derives from the lease. In every case, it always comes from the lease. So if rent is obligated under the lease, so then UNO goes with it. If rent is not obligated under the lease, then obviously UNO doesn't go with it. You're not going to go past the lease, right? The lease describes what everyone's responsibilities are. So yes, so while there's to maintain the status quo, right? So you say, okay, let's follow the lease. Well, what does the lease say? Well, the lease says that I don't have to pay rent. Now, I understand that they're disputing the 18 modification and whether it's authentic validity or not, and that has something to do with this old board, new board conflict that's going on there. They don't, you know, whatever was going on there. But it's clear that the judge found that the 18 modification was valid, that the parties were acting under it. He felt like that was the status quo. The 18 modification specifically describes the speakeasy, like you're referring to earlier, about that it was going to have live events and so on. That's only in the 18 modification, right? There are other that the 18 modification also imposes on the tenant to do all these repairs. They don't deny any of this, right? So clearly 18 modification is in effect, and if that's the case, so then any question about UNO would go to the lease in terms of rent, and if rent hasn't started yet because they did some sort of an exchange for consideration, so then we're not up to UNO. We're not up to rent. We can't be up to UNO.
Do you have a trial date, counsel?
A trial date? No, Your Honor, we're not.
And there's a receivership order that was in effect but has now been lifted?
Yes, there was a foreclosure action, and there was a receiver order earlier in the, I don't know, maybe about a year or so ago. I'm trying to remember, but ultimately the foreclosure action was resolved, and so that kind of went away.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Naomi Zeltzer, appearing on behalf of the defendant counterclaim respondent, Esteban Caxarac. Your Honor, this court should affirm the lower court's decision in dismissing the sole cause of action of the defendant appellant, which is tortious interference of a contract. Ultimately, the court issued correctly, and on appeal, the issue was completely abandoned by the defendant appellant. There is well-settled case law, Anonymous versus Anonymous, Weiss versus Ream, Bell, Freeman, Tribbs versus 326-338 East 100th LLC, where the First Department held that if you do not raise any arguments raised below to the appellate courts, that those issues are abandoned, which is exactly what we have here. Now, counsel did respond to the respondent's brief by raising the issues that were raised below and the arguments. However, he does not raise the issue with regards to the abandonment. And even if the court could consider it, there are case law that says you cannot raise it in reply. Doe versus Archdiocese of New York is one of the cases that just came out from the First Department, 2024, that specifically denies considering those issues on appeal.
Thank you, counsel.
Thank you.
Your Honor, could I have a brief rebuttal just on one issue?
I think I gave you 2 minutes of rebuttal. Yeah.
Could you address the use and occupancy? So you weren't, the Yellowstone didn't deal with use and occupancy because you weren't getting any kind of rent under the lease at that point, counsel said?
That's not correct. In the record, there is previous rent payments that were made by the tenant, and they allegedly, if you look at the record and the checks that are attached to the record, it doesn't say future rent, it doesn't say anything. It says the month like October or August 2019 rent. It's nothing other than rent. Now, with regard to the use and occupancy, it is well established in this district as well as at the Second Department that before the court issues a Yellowstone injunction, one of the most requirements is that there has to be some kind of conditions attached to it. This Yellowstone injunction had no conditions attached to it. They had no timeline and no monetary damages, notwithstanding the fact that the tenant paid rent previously.
Yeah, but a Yellowstone injunction is different than a regular injunction. You
I
understand that?
I'm
Different
sorry for
criteria.
mislabeling it. It's use and occupancy. There's well-established case law in this department that use and occupancy is warranted when there's a Yellowstone injunction. This case was commenced, and the rent issue is addressed in the record at page 304, where it clearly says, in the rider dated December 4, 2014, it says, the basic rent charges shall commence on the earlier to occur of either the original operation, or opening and operations of the restaurant, or the issuance of the certificate of occupancy. In this case, the tenant started operating in October 2019. Since October 2019, they had temporary certificates of occupancy. They let those temporary certificates of occupancy expire intentionally, but to say, I don't have to pay rent, but I can operate because there's no certificate of occupancy. But provision, the record in the page 304 clearly states, rent is due upon the earlier of the happening of the two. Therefore, based on this provision, which wasn't amended, requires the tenant to pay use and occupancy over $1.5 million to date.
Thank you, counsel.
Thank you, Your Honor.
Thank you all. Cobblestone Lofts v. Admiral Indemnity. Please.
Good afternoon, Your Honor. May it please the court, Gregory Lair on behalf of the appellant, Great American Insurance Company. Your Honor, we're here today to provide essentially the court an ideal opportunity to re-examine this court's decision in 2006, the ruling in Long Island Lighting Company versus Allianz, where the court issued a ruling and determined that there was a justiciable controversy involving an excess insurer. In that decision, it was decided on a 3-2 ruling with what we, in our view, was a well-reasoned dissent, one that we obviously agree with and is more applicable to the issue before the court today. If I may, if I could just
You don't
begin.
think that you all did a denial? You think that you left the door open to the possibility of covering?
We did leave the door open. There were the last 2 position letters that were issued to Cobblestone specifically said if there is a finding of bodily injury against Cobblestone, we will reevaluate the coverage determination and at that point determine whether there was coverage under the excess policy. So that door was left open. And even there was an invitation or an expression by Great American that they would participate in settlement discussions, in mediation, so they did not foreclose any possibility that there might be coverage under the
But
policy.
are you allowed to do that when you're presented with evidence that we're going to get into the excess policy?
Well,
I mean, for example, the McMahon family, I don't know if they had 12 years of this, but their rent was $15,000 a month. You times that by 12, you're getting above $2 million, right, just with that. So, I don't know. I mean, over the years, because it's 12 years, 12 months a year, just trust me on that. It's more than $2 million. So aren't we talking excess already?
We are not, Your Honor, respectfully. This is general liability policy, and it only provides coverage for bodily injury and property damage.
What about the toxic nature of mold? Like the toxic nature, isn't there a personal injury included in their claim?
If there is a liability against Cobblestone for bodily injury resulting from toxic mold, there very well might be coverage under the policy. But the only evidence in this record is a letter written by the primary insurer, Admiral, to Cobblestone saying there is a demand for $50 million. It appears you might not have coverage on your excess policy. You should have personal counsel involved. That's the only evidence in this record as to the possibility for it to hit into the excess layer.
If Admiral has to pay, do you have to pay?
Excuse me, Your Honor?
If Admiral should have to pay, do you have to pay?
Almost certainly, because we follow form, the Great American policy follows form to Admiral. There are some very slight differences, but I don't think any meaningful differences for
So
purposes of
Admiral is defending, we know that. Is Admiral, and I know they were dropped out of this case, I think. I mean, they were originally a defendant in this case, now they're not a defendant in this case, but haven't they agreed that if there's any indemnification that they would also indemnify? So if they've agreed to that, how can you have a continuing reservation?
Admiral has a continuing reservation. They have not made a commitment to indemnify. They, just the same way as Great American, are waiting to see what the liability is, if any, against.
Well, after 15 years, you don't know what the liability is in this
Well, that's one of the unique aspects of this case, because after this court's ruling in 2018, there were only 3 causes of action left against Cobblestone, a ruling that was issued.
So for what reason do you say you're not liable on this policy?
I'm sorry, can you repeat that?
What is your reason for claiming lack of liability?
Primarily because the remaining causes of action sound in contract, and that's what this court said. This court issued a ruling affirming the.
So there's a statute. There's a statutory violation cause of action.
Yes,
right?
the multiple dwelling law.
Or the multiple dwelling law, and then there's a contract.
Breach of contract for.
There's the 2 causes of action. That's it.
That's it. Well, and then a cause of action for injunctive relief, but that's really not at issue here. Really what it is ultimately at issue is, can there be an award of bodily injury or property damage stemming from these essentially breach of contract claims that remain?
Why couldn't there, if there's a statutory claim under the MDL that you aren't properly taking care of the apartment, and as a result there's all this damage that caused injury? I mean, doesn't that flow?
That would be
easily?
the contractors who did the work. The only potential liability against Cobblestone under that statute are civil penalties. We haven't seen any case law indicating that there can be anything more than, say, economic loss that is awarded to against the condominium board.
The liability doesn't arise contractually from Cobblestone's failure to maintain the condo?
That would be economic loss, Your Honor. We are only covering bodily injury and property damage.
So their failure to maintain the apartment, the condominium, causes a bodily injury to the McMahons, and Cobblestone's liability to the McMahons stems from the declaration and bylaws, does it not?
It does, and that's a
Did you say
contract
property
action.
damage also?
Excuse me, Your Honor?
Did you say you cover property damage also?
Covers property damage and bodily injury. But again, there's nothing in this record indicating that there is going to be any damages against Cobblestone in excess of the primary layer. It doesn't exist. So it results in purely an advisory opinion that the trial court issued. There's no justiciability here because we don't have any evidence, certainly nothing that we saw like in Long Island Lighting, where there at least was an expert's opinion that provide a basis for the potential damages against the defendant. We don't even have that here.
And you're saying the fact that the McMahons have been out of their apartment for 12 years at $15,000 a month, that's not the kind of damage, you would not cover that? That's not, they're out of their apartment because there was property damage to their apartment. So how is that not covered?
We don't cover, that's economic loss, Your Honor. We only cover the actual property damage. And in fact, there was an indication that there was only $130,000 of personal property damage as a result of the leaking into the apartment. So we don't cover the...
So that if there was a condition that affected the environment of the apartment itself, where it's unlivable, you wouldn't consider that environmental damage property damage?
It's not property damage.
You mean only the furniture, if the water affected the furniture and the carpets?
If there is a claim for that and that is an award against Cobblestone, there's a good possibility that that is covered. But that is not what is currently at issue.
So your contractual exclusion is that for which the insured is obligated to pay damages by reason of the assumption of liability in a contract or agreement. So doesn't that bespeak where someone agrees to indemnify someone in a contract for damages that they may cause? This is, it's not from the assumption of liability if your liability arises from the fact that you failed to comply with the declaration and bylaws of the condominium.
Yes, Justice Friedman, I think that is a correct reading of the policy. And we advance the argument.
I would say it doesn't cover that. If it's dealing with an indemnification situation, not where your liability arises from, not where Cobblestone's liability arises from the fact that it did not comply with its, not that it assumed, it just didn't comply with its contract under the bylaws and declaration.
That would not be an accident under the policy. That's a general liability policy only provides coverage for occurrences. Occurrences are defined as accidents. So if Cobblestone breaches a contract,
someone is injured from water coming through the masonry and causes injury, that's not an accident?
we don't. It depends on what the cause of action is that gives rise to the damages against Cobblestone, which we don't know. It's all speculative, which is why we are saying that there is no
Accidents
justiciable
including
controversy.
continuous or repeated exposure to substantially the same general harmful conditions, the continuing water coming through the wall, moisture coming through the wall.
I understand what Your Honor is saying, but again, we don't know where that is going to go ultimately. We don't have anything coming close to a finding of liability against Cobblestone. We just have two
You're
causes
saying
of-
this finding was premature by
Exactly,
the judge.
Your Honor. Yes.
And that you should have to continue litigating it and then figure out if you're involved or not.
Yes, the Supreme Court made a finding of
Why is
coverage
it
under the policy.
premature? If Cobblestone is found liable, then you're exposed. If it's not, then you're not.
Well, the same, I mean,
Contingent
Admiral
liability.
doesn't even have a finding of coverage against it as the primary insurer. So it's premature for there to be a finding of coverage under the excess policy when there isn't even a finding of coverage under the Admiral primary policy that we follow form to.
All right, thank you, counsel. You have time to rebuttal.
With respect to the question of leaving the door...
Why don't you just state your name?
I'm sorry?
So we know who you are. Introduce yourself to the court.
Robert Sullivan, I represent the Cobblestone Loft Condominium.
Thank you.
On the question of leaving open the door, on the question of whether this is ripeness, there are 3 distinct letters that Great American wrote in response to their position that they did not cover this because breach of contract was not covered. They wrote 3 separate letters. The first letter in September of 2018, they said, we're going to close our file. I think that's as definitive as...
Yeah, but then they wrote different letters after that.
Well, the second letter, the 22619 and
in the beginning of the next
2520,
right.
They again reemphasized their position that the breach of contract claims are not covered. And then they said, well...
But they left the door open, I thought.
Well, they left the door open. They said, if there is a finding of bodily injury or property damage, we may reassess our position. But the whole
So why, in
case...
the face of the contractual exclusion, is there coverage for breach of contract?
Well, first of all, Your Honor, on the contractual exclusion, I think there are 2 separate issues here. On the issue of whether or not there's a breach of contract and the statutory claim is covered, Justice Knock very clearly in his opinion dealt with that. He said the question here is not what the cause of action is, it's what the type of damage that emanates from that. And he addressed it on a coverage basis, taking a look at the policy and what is covered and not covered. And he said there's no exclusion there for breach of contract or statutory claims. There's coverage if there is damage, bodily injury, or property damage emanating from an occurrence, which is an accident.
And after 11 or 12 years, nothing's happened in the underlying action?
Oh, it's, I don't represent...
I mean, I know they've been up here a lot of times.
Yeah, I don't represent Cobblestone on that. It's on trial calendar now. That's resolving itself. But on the question...
Your colleague said several times, I believe, that it's premature. Why isn't it premature?
I'm sorry?
Why isn't it premature?
Well, several reasons, I think. And again, Justice Knock laid this out very well in his opinion. First of all, I submit that the 3 letters regarding the disclaimer of coverage are very definitive. It was very clear they weren't going to cover breach of contract. And, you know, if you suffer a judgment of $10 million, come back and call us. But they were very clear that they took the position that breach of contract was not covered. The second issue on the question of the potential damage, I think, Justice Moulton, you're correct. There's a lot of time, loss of use here on the part of the McMahons, but you also have the primary carrier, somebody who's reserved this loss, who understands and who's evaluated it, and went ahead and said, we think it could pierce into the level, whether it's $50 million settlement or it's $10 million or a penny over $1 million.
But I asked counsel what was going on with the primary carrier. I know you let them out of this case, Admiral, but are they still?
They are defending.
I know they're defending, but we know defending and indemnifying are 2 different things. But have they agreed to indemnification, or they still have a reservation of rights?
They issued a, quote, reservation of rights on issues like punitive damages and whether or not there's intentional acts. They withdrew all the other types of objections that Great American had to cover. That's why I let them out of the case. I mean, I can't contest that they're covered for punitive damages.
Right.
I can't, and that's all on the record. I can't contest all that. But all of the contractual exclusion, they withdrew that. Whether or not a breach of contract was covered or not, they withdrew that.
I apologize. Admiral had a similar provision for contractual liability exclusion. You're saying Admiral withdrew that?
They did.
Finding that that exclusion doesn't exist in this case.
They withdrew it, and that's all I needed to know at that point in time. We took the position, as we did with Great American, that, as Justice Friedman, you suggested, it's not an assumption of liability, which is an indemnity claim. That's not the question here. That's not an issue here. That isn't what Cobblestone
did. The word
did.
assumption has to mean something.
Right.
The word assumption has to mean something there.
Right, but it's not, and there's case law that talks about what they're talking about as an indemnity claim, and that's not this case.
As opposed to just being a plain breach of contract.
That's correct. Now, this is not a case where Cobblestone didn't fix a light or a window in the condominium, and the McMahons paid for it and are seeking reimbursement. This is different. What is, and again, Justice Knock looked at this from the coverage standpoint, looking at the coverage of the policy. These are damages, bodily injury or property damage, emanating from an occurrence, which is an accident. And I think the analysis before they didn't fix the leak, and as a result of that, there's a potential for personal injury and property damage to McMahon's. And that's what Justice Knock looked at, and he looked at it from a pure coverage standpoint. That's the position, quite frankly, ultimately Admiral got to, which is why we let him out of the case. And I think that's the same position that should apply to
Thank you, Counsel.
Great American as well.
Ron, I might just use the 2 minutes to just review the communications that were given to Cobblestone, because it's really quite different than what my colleague has presented to the court. First, in Great American's letter of February 26, 2019, it specifically said that coverage does not appear to be available for the underlying action, but in the unlikely event that damages are awarded to plaintiffs for bodily injury and/or property damage, Great American will further assess its coverage position. This is the letter at record 1171. As for Admiral's position letter, the letter dated January 12, 2022 at the record 1111, Admiral clearly says on page 15 of that letter that there may be potential obligation to indemnify Cobblestone. It reiterates all its reservations of right. What it did was, in its February 24th, 2022 letter, was it withdrew its reservation on the contract exclusion. And the reason why they did that was so that it alleviated a conflict between Admiral and Cobblestone with respect to Admiral's desire to appoint new defense counsel. They wanted their own lawyer in there to defend Cobblestone. Cobblestone said no, because you have a reservation of rights, so we get to choose our own counsel. So Admiral just merely elected to withdraw that. They didn't make a substantive decision on whether that exclusion applies or not. They did it for purposes of providing a defense with their own lawyer. And if I can just make
But they can't tomorrow change their position on that.
Not on
can they?
that. I mean, certainly I would suspect that there's a waiver argument or an estoppel argument for Admiral, but I'm not here to carry their water on that. We kept it in because we don't know what ultimately the liability is going to be. Mr. Sullivan specifically said that there was Justice Knox said we have to look at the type of damage emanating from the cause of action. That's fine. We agree with that. But what we don't know is if that damage is going to emanate from an occurrence. That is the uncertainty here, and that's why we say that this is a non-justiciable controversy, because it's a premature ruling on the availability of coverage under an excess policy where there has not even been a determination of coverage under the primary policy. It's kind of putting the cart before the horse.
Thank you, Counsel. Thank you both.
Thank you very much, Your Honor.
Okay, lastly, People versus Maori Perdomo.
Good afternoon, and may it please the court. Barbara Zolot for Appellant Amori Perdomo. I'd like to focus my argument on counsel's unwarranted interference with, on the court's unwarranted interference with defense counsel's summation. Here, having been denied the EED defense counsel shifted gears in summation to argue that Mr. Perdomo lacked the intent to commit any of the charged offenses altogether. Mr. Perdomo's mental state and its relationship to intent was so important to counsel's argument that his first words in summation, even before saying, "Good morning, ladies and gentlemen," was to remind the
Is this preserved, first of all?
This is not preserved insofar as counsel didn't say anything in the midst of his summation, and we couldn't expect him to. He did not say anything after the summation, but we submit it would have been futile given the judge's position on these things, and we do ask the court to exercise its interest of justice jurisdiction here in recognition of how fundamental summation is, that the intent argument was critical to the course that defense counsel had chosen to chart once EED was denied. Getting back to the...
But, okay, so getting to the substance of the comments made by defense counsel, doesn't it look like he's fighting the battle that he lost already by saying that the defendant lost control?
Right. Your Honor is referencing the second argument that defense counsel tried to make, that the court felt was intruding into perhaps smuggling in the EED defense. And I do want to address why the court attempting to correct that misimpression still went too far. But I do want to focus the court on counsel's first argument, which was, what had happened was defense counsel opened with reminding the jury of Mr. Perdomo's own statements regarding his mental state. In that moment, I was not thinking of anything. I was just crazed. I lost self-control. That's how he opened. He reminded the jury throughout his defense of those statements and Mr. Perdomo's testimony to that effect. Yet when he reached the climactic point of his summation, what all of that had been leading to, when he sought to do what lawyers need to do in summation, which was to connect up this record evidence to the jury's consideration of the element of intent, at that point, the court inexplicably sustained the prosecutor's objection.
He may have been successful, though, in that the jury acquitted on murder second.
Well, the jury acquitted. We don't know why. There was this videotaped interrogation, which the jury saw in full, and despite the really unthinkable, senseless tragedy of this crime, my client on that video is, when the detectives are out of the room and the camera's running, he doesn't know it, he's just completely shattered. Maybe the jury felt sorry for him. We're all speculating here why the jury did what it did. But the fact remains is that the course the counsel charted was to argue that Mr. Perdomo, given how undone he was because of all that had happened, meant that he couldn't form the conscious objective to commit these crimes. He lacked the intent altogether.
Is there any psychological evidence presented?
Pardon?
Any psychological evidence presented to support the notion that he had emotional disturbance?
Well, there was none, and of course the court did deny the EED defense, but what counsel had pivoted to was making a very classic intent argument based on Mr. Perdomo's own statements to law enforcement and then to his testimony, in which he said over and over again, I didn't know what I was doing, I was crazed, I blacked out. And this was the defense during the summation. This is what defense counsel was advocating to the jury in his last chance to win an acquittal for his client. And even now on appeal, my adversary really doesn't seem able to come up with a reason why what defense counsel argued was improper. And yet the court essentially told the jury that it was, and don't consider it. And then there was the second argument that defense counsel attempted to make, which Your Honor referenced, where there was this, I think it was semantics, I'm not sure what defense counsel intended, but he implied that the court would instruct that Mr. Perdomo had lost control. To the extent his semantics were bad, the court went way too far in how he attempted to cure it. He again essentially communicated this, don't think about this intent argument at all. It isn't that Mr. Perdomo's loss of control isn't something that has any merit. So the court took these key issues essentially away from the jury. And this was very prejudicial. This was the defense. And we ask for reversal on that basis.
Thank you, counsel. You have time in rebuttal.
Good afternoon. May it please the court. Of course, the trial judge didn't hear any of those arguments, and that's very significant. He could have given some sort of curative. I do think the court was absolutely correct with the one comment that sort of sounds almost like defense counsel was predicting a directed verdict. He was absolutely correct to sustain that objection. In hindsight, 20, it's easy to look back on a cold record and say, well, the first comment, on the cold record, maybe the judge acted a little bit too quickly, but you've had this extended colloquy a couple of days before concerning the EED defense. I think that's why the judge thought that's where counsel was going. In some respects, I think, like you were saying, he's sort of arguing it's almost as if he sort of converted that argument. And in the end, it's a very good reason why the defendant never argued that essentially this sustained objection substantially impaired his ability to deliver a summation, where throughout the summation, he talks about the defendant being crazed, upset, worried, distressed, angry. He snapped, feared for his safety, was out of control, blacked out, didn't remember, lost his mind, lost his self-control. I think the jury obviously understood counsel's point that that in his view, the people had not established the defendant's intent for these crimes. So I urge the court not to review this in the interest of justice, but certainly I don't think there's a substantial impairment rising to the level of sort of due process violation, the equivalent of denying a defendant summation.
Actually, the court says, I will submit to you and defendant lost control. This is defense counsel. He did not intend to cause serious physical injury, as his honor will instruct you. So he's talking about the court instructing, and is it off the mark for the court to say, I'm not going to be instructing about that?
I don't believe it was. I believe that the second comment, again.
And I submit to you when defendant lost control, he did not intend to cause serious physical injury, as his honor will instruct you. So he's just responding to, they're not going to be hearing that instruction.
Correct. If the court has no further questions, we'd ask that you affirm.
Thank you, counsel.
Thank you.
2 quick points. Maybe the jury understood that intent, Mr. Perdomo's mental state related to intent, but given at least that first comment where the first argument where the court sustained the objection for no reason, essentially took the intent argument away from the jury, said essentially, don't pay attention to this, there's really no excuse for that. As for the second situation that Justice Friedman just referenced, yes, counsel semantics were not good, and the court wanted to correct any misimpression about what the court would or would not be instructing. But as I said before, the court went too far. The proper instruction, what the court should have said is whether Mr. Perdomo lost control and how that impacts the element of intent is for you to decide. I will be giving you no instruction on that. Such a simpler way to do it, instead of suggesting that none of these intent arguments, Mr. Perdomo's loss of control, forget all that garbage, ignore it. And this was counsel's chosen course in summation, which is very crucial to remember. Thank you.
Thank you, counsel. Thank you both.
Lobby, be advised, court is over.